Yes. All the
For
matters.
adjournments, page number 4, 16. Page number 5, 17 to 22.
19 minutes. Page number 19. There is unwell. There is unwell. Maybe after 2 weeks. Page number 19.
At the request of counsel for the appellant, on the ground that the arguing counsel is unwell, adjourn to.
312.
Serial number 15, my lord. I'm not well, my lord. Not well. I'm suffering from vertigo, my lord. Next week, my lord.
We will hear it, Mr. Raghunath.
Yes, next week, my lord.
We'll hear it. We have heard, almost finished.
Yes, my lord. I'm suffering from vertigo, my lord. I'm unable to.
We'll accommodate you.
Yes.
Right, okay?
My lord,
Just have it.
serial number
Have it on Tuesday, my lord. Next.
When do you want?
Tuesday, my lord.
Tuesday,
Yes,
okay.
my lord.
List on Tuesday.
19,
You
11.
have a problem, vertigo problem?
Yes, my lord. I'm having a vertigo.
Okay.
19,
My lord.
11.
19.
serial number 24. My lord.
Yes,
Page number 6, 23 to 25.
Serial number 24, my lord. Both
Yes.
sides present, my lord. We have inconvenience today, my lord,
you file your submissions, both of you.
and both sides is represented by the learned senior counsel. And we need some more time, at least date may be fixed somewhere in the month of January. my lord.
Submissions be made, request is made for adjournment. On behalf of the appellant, we notify on.
That the name of Sudat Sampath be added for the council.
So written submissions shall be filed by the counsel for both the parties. For whose name need to be shown? Mr. No, Mr. B.K. Sampath Kumar is.
Senior.
Just say that the name of Mr. Suraj Sampath be shown in place of Mr. B.K. Sampath for the respondent in the cause list. Next,
16, 125. Page number 7, 26 to 29.
My lord, serial number 29, my lord, there's some inconvenience. I appear for the appellant. I seek
Which
some
matter?
accommodation. Serial number 29.
at the request of counsel for the appellants, re-notify. Right, are submissions there on record?
No, my lord.
See, there is some issue on notice.
9.3.
Notice was dispensed with, my lord. Responded 2 to 5 are the arbitrators.
Okay,
The notice was dispensed.
okay. Submissions, you will file your submissions.
My lord, 1 month, some time may be given.
Submissions be filed by both the parties along with the judgment they want to rely upon within 4 weeks.
20th January 25.
Much obliged.
My lord, one submission. In serial number 21, I am for the appellant, my lord. In this, we have engaged the senior counsel. I pray for one accommodation, my lord.
16 occasions they have taken.
Previous occasion, my lord, I was sick in time.
Not even exact. 16 consecutive times.
May I make a submission, my lord? Previous occasion, I have sick in time. The lordship has directed to file the written submission. We have already filed our synopsis and written submission in this case, my lord. Appellant has already filed. We have not received any copy from the respondent. In this case, we are engaging a senior counsel. I apologize for this inconvenience, but one accommodation, my lord. We have already engaged.
But that's fine. For 3 other coordinate benches, they have gone through the Rolodex of excuses that exist for the
Just pass over. We'll take it. Let's see that.
Serial number 12 in the second district order.
See, we will see it. We will retain it. Let's see if we can take up the second list. Otherwise,
Serial number,
number 18.
which list? List number, list number, sir? 18.
that he will be here on the first list. Who is mentioning 18? Yes. You for whom? Just say that adjournment is sought by the counsel for the appellant, re-notify. Submissions along with the judgment shall be filed within 4 weeks.
8/1/25.
My lord, release to serial number 11, my lord. I've informed the other side, my lord.
Who is
Right.
there other side? At the
Prashant,
request of counsel. List
counsel who is
two,
on record, I have.
list two,
Yes, my lord. Release to serial number 11.
we will not touch it, we will come back. If we take it up, then we will take it. Next,
Let's-
Serial number.
call the list.
They moved the memo earlier, last month, 23, 10, 24, and they will be taken up.
Check up that.
So we will verify. 23/10 more minutes. Moved on 23/10. 23/10.
What happened, ma'am? Why is it not listed? Just call for it once it is listed, no? We should know. We'll take it up today. Just do one thing, just give a date on this. When do you want? This date.
21st.
See that mistake at our side. The date given for today.
For the appellant and
22. Yes, ma'am. Louder. You are appearing, Mr. Unikrishnan.
My lord, in fact, last occasion also, they said the same issue, they want to engage a
Your
CJ.
lordship,
But my lord, I have no objection
need-
because yesterday they informed me, but I
Was there any date, ma'am, in this?
What's the date given? 22.
We'll not adjourn this. Ma'am.
your lordship, actually, our clients, they are still, deciding on on whom to appoint as the senior
That is
advocate.
his concern. We are not concerned. Let's be very clear.
Apologies, your lordship, a short accommodation, your
On
lordship,
cost,
a short accommodation, your
on
lordship
cost.
can have it on the next week, your
on
lordship.
cost,
Your lordship can,
pay cost to the bar association.
if the,
bar association you pay, it's okay.
Okay, we don't want, that's the reason we give a date so that you have the knowledge. And when was the last date given? Tell us. When was that? How many weeks back? That's the reason.
22nd.
Just say that as a last opportunity, the matter is adjourned to, is adjourned on the request of counsel for the respondent. 2, the party shall file the written submissions along with the judgment they want to rely upon. Just give a date.
22nd.
5/12.
Publication.
Next,
We have also filed the English translation of the
Serial number 10, my lord.
yes,
10
Serial
order,
number 10.
sir. 10 is in order, sir.
I've intimated the other side. I'm not feeling well
No.
today, my lord. Firstly, said.
at the request of counsel for the appellant on the ground that he will re-notify.
Sir, for respondents. Please for respondents.
You're for the respondent?
Respondent. I've intimated the appellant.
Just wait, let them come. We'll just see that.
Please, my lord.
Serial number 1. The Ex-parte.
My lord, I'm appealing to the appellant, my lord, in this matter. We will take
Mm-hmm.
the substitute service, my lord. Substitute service. We have filed an application.
This is R3 is common in all the matters.
Yes, my lord. He has been served also in one of the matter.
That's right, but they are not appearing. That's what we noted on the last date.
Yes, my lord.
Now, the contesting party is R3 only.
R3 is not contesting party, my lord. He
But
is-
you are the contesting party, no?
I've imposed areas of tax as well as a penalty. I have two concurrent orders in my favor, the first appellate order and the writ petition.
Then I don't think there is any purpose, ma'am, to serve R3. We'll dispense with.
Please,
You argue the matter.
Lord, Lordship,
argue?
kindly have it next week, my lord. I'll get prepared myself.
What is the role of R3?
But he's apparently purchased the vehicle from it.
Ah,
That is inter se them. I am concerned with the illegal use of the vehicle without taking a fresh certificate of registration. And so therefore, for the period of non-use, I have imposed tax and collected a penalty.
The vehicles were not used. It was kept in the yard, my lord.
There is an inspection
Then it
report,
has
there are
been-
two concurrent orders. There are two concurrent orders of the joint commissioner who sits in the appellate authority.
The
as well as
vehicles
the
have
learned single
been,
judge, who considers, learned single judge's order considers all the law.
shall we dispense with in these three, in the other two matters?
please,
See, he is not coming. Was he there before the learner single
No.
judge? He was not there.
there's not.
Today in these proceedings also, he is not there.
No.
If you want, we can dispense with the service to R3. It's
Please.
basically inter se between both of you.
Please,
Shall we do that?
please, my lord.
Just say that respondent number 3 is still unserved. In writ appeal number 1446 of 2018 and 1448, 2018. Though has been served in WA 1447 of 2018. He is not appearing in these proceedings. We have been informed that he was also not appearing before the learned single judge.
But the order says so, the judgment says.
Yeah, if that be so, comma, the learner, just say that the learner counsel for the appellant states that in view of the above position, comma, the notice to respondent number 3 in the aforesaid 2 appeals be dispensed with.
May I make one submission? Instead of saying dispense with, if your lordships are pleased to say held sufficient and set ex-parte.
See, technically in these 2 appeals, he has not been served,
I understand,
technically.
but it arises out of common order.
That's the reason dispense with, let's see that. The liability can't shift on him. That's their case also. The liability must shift on him. That's right.
That is inter se them.
I intercede them. No, we are saying only thing is that if he
I understand.
comes,
I
if he
understand.
comes back,
It hurts only them. So far as I am concerned, I believe that they are in default as the person who had the hypothecation.
and you claim the tax from them.
I've recovered it.
you
My lord,
recover
it is now 60 lakhs have been recovered. My lord, vehicles are not in existence. The vehicles which are not in existence, they are imposing the tax, my lord.
And let
See,
them withdraw it.
we don't mind, you want to serve them. How would you serve? Is he available at that address?
He is available in that address, my lord. He has got the scrap yard there.
Let there be a paper publication. my lord. If they are keen on shifting liability, I am only concerned with upholding my order and my appellate order of the joint commissioner. And the learned single judge's order is in my favor, so I will be relying on it. If they are keen on shifting liability, let them take a view.
We will take, my lord, safer side.
Just cut that order. Still, the respondent number 3 is still unserved in writ appeal number 46 and 48. Let fresh notice be issued for service on respondent number 3, including dusty summons. Returnable on.
13,125.
Obliged.
Obliged.
And 1449 also. 46, 48 and 49 and 50. There are 4 appeals, no?
My lord.
And 1450. Fresh,
The five appeal.
fresh notice in all these 4. Except 47.
Obliged.
Serial number 2. Srinivas N.
Yes.
Yesterday I filed the necessary application. I'm sorry, I was not able to file it earlier.
What have you filed?
I LR applications, my lord, to bring the LRs of the first appellant.
What is the case? What is your case?
Under section 37, my lord, the Arbitration Act, my lord, rejecting
right.
counterclaim.
But what is the proof for 1,000 rupees?
My lord, I have produced the exhibits, my lord,
Where?
in the trial court, my lord.
Which is that page?
My lord, I have not fully ready. I kindly have it tomorrow, man. Tomorrow or day after.
Is the exhibit there?
Yes, my lord, it's there, my lord.
But the trial court doesn't say so.
It's there, my lord.
You see page 19. Paragraph 12.
But exhibit P19 would be the exhibit P9A would be the valuation report, and exhibit P10 is the sub-registrar's guided value. My lord.
P19.
P19 are the rental agreement, P14. And exhibit P9 is the valuation report, and exhibit P10 is the sub-registrar's.
Where are the exhibits here in this appeal?
I have not made. I'll file it, man. A short accommodation may be given, my lord. I'll file the relevant exhibits.
Is the trial court record here? Trial court record. Just say that at the request of counsel for the appellant, Adjournment.
912. Serial number 3. Shivanayak Krishna Bhatt. Serial number 3.
Appearing for appellant.
Let fresh notice be issued to respondent number, to the respondent returnable. Is the respondent appearing? What do you want to do?
I'm filing a memo that matter may be disposed of as infructuous.
Just show us that. The learner counsel for the appellant has filed a memo which reads as under.
One humble submission is that, my lords, I may be given liberty to approach this honorable court if any
Oh,
subsequent.
this is the same, na, where it was.
Please.
This, the petition, the accordingly, the appeal is dismissed as infructuous. Next.
Serial number 4.
For your honor, R 1 to 3, your honor.
But R4 is the learned arbitrator. I am placing a memo to dispense with the service of notice.
Or 1 to 3, your honor.
What is this?
But this is challenging section 34.
What are you filing?
I am filing a memo saying that R4 is the learned arbitrator and he is only a formal party. Therefore, service of notice to R4 may kindly be dispensed.
The service on respondent number 4 is dispensed with. The service on respondent number 4, who was the arbitrator, is dispensed with. In terms of in view of the memo filed by the learner counsel for the appellant.
LCR may be called for.
Who is appearing for 1 to 3?
I am appearing for 1 to 3, your honor.
Oh.
Konkan Railway.
You are ready to argue?
But today, man.
Just say that counsel for the parties to file the written submissions.
And LCR may be called.
Trial court record be requisitioned before the next date of hearing.
Please.
Great, Your Honor. Much obliged.
13-125. Serial number 5.
Appearing for the appellant, my lords.
My lords, appearing for the respondent, my lords. My lords, I seek 2 weeks adjournments, my lord. Due to personal inconvenience, senior is unable to attend, my lords.
Shall I have a submission, my lords?
Hmm.
Can you produce the order sheet, my lords?
Who
Respondent,
who had mentioned the matter?
My lords, not us.
Just show the file. Who's been taking? Adjournment is.
My
What is
lords,
the difficulty?
final hearing matter, my lords, it's listed in orders. They have moved a memo for retirement by Narsimhan.
Just say that, ma'am, no, we want you, the appellant must appear in the proceedings. Then only we'll allow you to retire. You have filed it up. No, acha, now you would be appearing?
I'll be appearing. Sir.
Okay.
I'm on record, I'll be appearing.
In place of Mr. K.V. Narasimhan.
Yes, yes.
Yes.
He is withdrawing, he's withdrawing his wakalat.
Yes.
Yes, my lord.
Okay.
I'm on
It's
record from
just,
day one.
just say this, that Miss M.S. Rupa appears for the appellant, states that henceforth she shall appear for the appellant. First of all, at the request of counsel for the respondent, comma, adjourn to, the registry is directed to delete the name of Mr. K.V. Narasimhan and K. Nitesh as counsel for the appellant. Next.
11-12.
Please, my lords.
Serial number 6. Zulfikar Kumar.
Appear for the respondent.
Appear for the appellant. This is a section 37 appeal. There was it is indicated that an application is not filed. In fact, this concerns a property dispute between landlord and tenant. I am the tenant. So the submission made on an earlier occasion was that there was an subsisting execution petition. And though I had the benefit of an interim order in 34 as well as in this proceedings, because it was subject to deposit of 50%, which could not be done, I did not get the benefit of the interim order. In the meanwhile, the execution petition proceeded and I had to hand over the property. So property is handed over. So to that extent, an application was to be filed. My difficulty is that this gentleman.
But in any case, you have handed what remains now.
No, only with respect to the mean profit. So this claim, Your Honor, had 3 parts. One was rental dues. Second was mean profits, because there was a clause in the contract which spoke of 10,000 rupees per day towards mean profits. The third was
which was given by the arbitrator.
Arbitrator awarded the whole
Whatever is the term in the
whatever the term, the arbitrator awarded the rentals, the mean profits, and to hand over the property. So but as on the date of award itself, all the rental dues were paid. In fact, Your Honor, what happened was that from 1965, they have a landlord-tenant relation. There were no disputes at all. It is one of well-known properties on the prime MG Road on MG Road. Because of COVID, because this was a ready-made formal garments store, formal shirts and trousers. Because of COVID, the entire business collapsed. So there was, admittedly, Your Honor, rentals were not paid for about 14 months. But thereafter, soon after the arbitration proceedings were initiated, all the rentals were paid as on the date of award. All the rentals were cleared. And even during the pendency of 34, as well as pendency of this 37 also, till the property was handed over, all the rentals were being paid regularly. There's no dispute on that also. So the only difficulty is that, Your Honor, that the mean profits, now the honorable arbitrator relies upon a particular judgment, a Nandram judgment, to come to the conclusion that I am due to pay the rentals as well as a mean profit, because he terms me as a tenant at sufferance. So that is the only point that I will want to argue before this honorable court.
But tell us one thing, notice was given, is it a statutory tenancy? No, this is purely contractual.
Contractual.
If that be so, then there is a stipulation in the contract. Unless and until you show us the law that even though it says 10,000 per day, the rentals were not so high. And you are liable or you are entitled to, or even if any mean profits need to be determined, that cannot be this kind of a mean profits. No, that will 10,000 means it will come for a month, there would be a amount.
3 lakh to 3,10,000.
Complete amount has been given, complete amount?
Complete amount with rentals also. So both have been awarded. So that is the only dispute.
That's possibly, you know, when he issued notice for the period before notice, the rentals, and post notice, the mean profits.
But you know, now I will definitely would want to argue this with some judgments. And this application, Your Honor, may take my submission on record.
You take your submission.
Yes, that it has been handed over. I'm sure my friend also will not dispute that.
With that?
Your Lords, insofar as the payment of rents and all of that is
No, with respect to
concerned,
this, handing over of the property.
Possession.
yes, we have recovered possession of the property through the execution proceedings. Lords, in fact, I would like to bring one thing to the court's notice. On the last date of hearing, they made a submission that they are challenging this award only so far as the mean profits are concerned.
He's saying so now.
Your Lords, I've even given them an opportunity that if you are actually contesting that matter in the execution proceedings, and your Lords permitted them additional time. In between, the execution matter had again come up. They are avoiding the execution proceedings completely. They have filed their wakalat, but all of a sudden they have been avoiding those proceedings. Your Lords, this is nothing but they are just dragging this along.
The only issue in execution is only the mean profits.
That's all. Yes.
Yes, Your Lords.
Or the rentals.
Yes. Oh, no, rentals have been paid. Paid.
Your
Only the
Lords.
mean profits. And the reason I was finding it a little difficult to get instructions is that this gentleman is now under psychiatric treatment. So I have now brought his daughter. She's just a youngster who has just passed out from college and she just started her job. I have brought her on board so that she can help us and instruct us with respect to this case. That is the reason I could not file that application also, because this gentleman, after this, he has gone into depression and he was on antidepressants, and now he's been on rehabilitation to come out of antidepressants. He's on psychiatric care. So that is the reason I could not file the application, but my submission can be recorded that all the property is handed over.
Your Lords, the
So
question over here.
Your Honor may give me an opportunity to argue. I will try to convince your Lords that mean profit, as far as mean profit is concerned, it may be a little excess, Your Honor.
Your Lords, insofar as instructions are concerned, this is only a point of law, Your Lords. There's no reason to keep protracting these proceedings.
No, that's the reason I said
When is the execution? What is the date?
The date of
The execution, the next date of hearing is in the coming month, Your Lords. I'm not exactly sure of the exact date, but in the coming month it has been.
Second week of December, second week of December, if I'm not mistaken.
Yes.
Just say that the learned counsel for the appellant states that the possession in respect of the suit property has been handed over to the respondents, all three respondents?
Yes, Your Honor.
Yes, Your Honor.
To the respondents.
They are siblings.
This submission of the learned counsel for the appellant is also acknowledged by the learned counsel for the respondents 1 to 3. As the only issue which remains for determination is the grant of mean profits by the learned arbitrator. The counsel for the parties to file their written submissions along with the judgment they want to rely upon. Within 3 weeks, re-notify the appeal on. File your submissions. We're looking.
Obliged. Grateful, Your Honor.
8125,
Obliged.
7, bill number 7, government advocate.
I appear for the appellant, my lord. My lord, we have to pay the process. We'll take today only, my lord. We'll pay, my lord.
I will accept notice for the respondents.
My lord, the learned friend.
You appear?
I appear, Tanmay
The same may
Rajkumar.
be taken on record.
So, though the notice to respondent is dispensed, with- is incomplete. So and so appears for the respondents, states that he shall file his wakalat within 1 week from today. You have the copy of the appeal?
I will hand over, my lord. I will
The
hand
copy
over.
of
I
the
will serve the
appeal be-
copy, my lord.
Let a copy of the appeal be given to the learned counsel for the respondent. Submission shall be filed by the parties along with their judgments. Along with the judgments before the next date of hearing. Re-notify on.
9/1/25
Much obliged, my lord.
or 8. Serial number 8, Shri Prakash.
Also,
9. Serial number 9, Shri Jayakar Shetty.
Connected matters are all listed on 25th. When I have informed the other side.
list on 25th, 11,
In the
25.
meanwhile, I will comply with whatever partial compliance I will do.
We don't know.
Well, I
Is
will
there
do
any
it.
compliance to be done?
I will do it
Right.
within that.
Next. Just say that re-notify 2511, liberty is granted to, where is he? Liberty is granted to Mr. Shetty to remove the objections, if any, in IA 2 of 2024.
Serial number 10.
And my lord, I'm appearing for respondent. Seeks
Pass over.
time, my lord. I will
Yes,
indicate
yes.
the
What do you say, Mr. Avinay? See, what is the challenge in this?
Question of limitation 2010 and 11 was the contract. 2021 is the suit. Alleging that we are due from 2011, the interest and the principal amount of 1 lakh. In the cross-examination, he admits, my lord, that on 2012, he makes a demand and keeps quiet for a period of 10 years. 2021 it's only a question of limitation, my lord. And the contract was for a period of 28 days, where we hired his car for a fixed amount. He says, though you hired it for 28 days, you have to pay for 31 days. Trial court allows without there being any receipts or these are the 2 points we may not support. Question of limitation and whether the contract provides.
What happened on limitation?
The trial court holds, my lord, that the limitation is valid.
Not an issue also.
No, issue is framed on limitation as an
Where is
additional
that?
issue. No, limitation, my lord, was filed.
See,
Page 25, my lord.
25.
Last additional issue 1.
The one. That one must be a preliminary issue.
Trial court holds, my lord, that page 50, that there was a contract which provides for 3 years. 3 years I'll calculate from the date of demand, that is in 2021, therefore it's valid.
Yes, would you like to argue?
my lord, can you have it in any shortest date, my lord? I will appear before this honorable court and commencement.
You're not well, na?
Not well, madam.
At the request of counsel for the respondent, re-notify after 2 weeks.
Obliged. Great.
7/1/25. Serial number 11, Shri Mithun.
For the appeal for respondent. Yes.
11.
This appeal against the arbitration. The matter is pending from 2016-17, my lord. And award was passed in 2017. They went up in this one, suit was filed before the city civil court. That was dismissed. Later, they filed one more MFE before the Honorable High Court. Matter was remanded back. Again, they approached the civil court and that was also dismissed. Now they have approached this court once it was dismissed for default. Later on, this Honorable Court directed them to deposit the arbitral amount. They have only deposited 50%. They ought to have deposited the entire thing. 1,44 lakhs plus interest is the order passed by the arbitrator. And they have deposited 90 lakhs and which have already received. Your Lordship may kindly direct them to deposit the balance.
You have taken that amount?
Yes, my lord. I have
As per the
furnished
last-
bank guarantee also.
As per the last order given by this honorable court, for 50% of the remaining amount, 25% was deposited, your lordship. 18 lakhs was deposited and the same has also been withdrawn from their end. We are speaking to the parties, so if a short accommodation may kindly be given, we will fix this, your lordship.
This is going on from 2017. It is being conducted as if it is a original suit. Much this one. Unfortunately, there is a delay of 10 to 11 years.
One short accommodation, Your Lordship.
Your lordship may kindly have it on next Monday or Tuesday. Let them either deposit or argue.
There is an order, which order is from June 22,
Yes, my lord.
50%.
That 50%, now the Supreme Court rulings consistently have said that the entire amount has to be deposited.
Right.
Subject to the order, 50% was initially deposited.
that
and the
I am
same
not
has been
disputing.
withdrawn, Your Lordship.
He is on the balance 50.
No, out of the balance 50, we have paid 18 lakhs. The remaining 54 lakhs is left out.
54 lakhs is due. Yeah, ought to.
We will pay that, Your Lordship. I mean, during the due process.
Shall we record?
No, Your Lordship, I'll have to.
I think
speak to
so.
the
That is
No, Your
fair
Lordship.
enough.
Is it 18 or 80?
18 is deposited, Your Lordship. Out of 72 lakhs, it was supposed to have been deposited. 18 lakhs is deposited as per the previous order.
1/8.
1/8.
But that's not 50%.
25% of the 50% remaining amount.
That's the order.
That's the order, Your Lordship.
Let them deposit 54 lakhs.
What do you say?
Lordship, a date may be fixed, Your Lord, 28th of this month. We are
Just
in
say
talks with the
that-
parties.
At the request of the counsel for the appellant. It says if the appellant deposits 50% of the amount in dispute, re-notify on. You file your submissions.
Your Lordship?
Submissions.
Submission is 54 lakhs they have to deposit.
I know, we will look into that.
Yes,
We'll set out for hearing. Just say submissions be filed.
512.
Please, Your Lordship.
IA2 of, sir.
IA2 has been withdrawn.
Serial number 12, on in number 1, my lord.
IA2 of 2024 having been dismissed as withdrawn on 29/2024, same shall not be shown in the cause list.
Serial number 12.
Yes, ma'am.
And for respondent number 1, my lord, in this matter.
For the appellant, there is a delay of 81 days in filing the appeal, my lord. Appeal is by NHA. They acquired the land of the respondent number 1 in 2014. After that, compensation determined by the land acquisition officer that has been paid. After that, as per section 3G5 of the act, they have.
See, what is the basis for the arbitrator to say so? How much is the increase?
Actually, basis is that from the date of as per act, date of preliminary notification is the criteria
That's
to
right.
determine, and prior
We are only on the amount. What is the basis for the amount?
basis he has to.
How much is the increase?
Actually, initial amount to 37 by SLO, he granted 2,37,000.
How much was the initial amount?
38,000 and odd. That will come around 38 lakhs. He enhanced that compensation from 2 crore 38 lakhs almost.
On
Almost
what
2 crores.
basis? You are for the
NHA, my lord.
Yes.
That's
And
it.
ma'am, what do you say?
My lord, the market value of that per sense is the 10 lakh, my lord. It is
How
a
would you
very
determine
meager
the market
amount.
value? How would you determine the market value?
My lord, the matter may be heard on merits next week, my lord.
See, we want, very well, really.
Yes, my lord.
What is the basis for him to say this is the market value?
Good.
Can't be in vacuum, no?
Yes, my lord.
Yes,
Only
my lord,
thing is
here
that,
on merits, my lord, on next week,
here,
on
what has
Monday.
happened is, particularly in that region, they have constructed some building without obtaining a conversion order or building plan. Based on that, they got the building amount, structure amount and all. Apart from that, they have not even produced any document to show that market value is this much. But arbitrator, he is the deciding authority. There is no limit for him to enhance the compensation. He decided this amount based on the conversion order and approved plan by the concerned. But there is no proper reasoning. But meantime,
No, he said this is in Mangalore.
yeah, Mangalore.
Yes, my lord,
What is it?
within the
How
city
much-
corporation limits.
2014.
That's no basis.
There's no basis, that is the reason. Meantime, I'll also verify.
Mangalore, everything, that's no basis, no?
But moreover, he has. to-
Why only 2 lakhs? Why not 3 lakhs? Why not 1 lakh? Why? It's like out of hat. that figure.
Yeah, otherwise it will happen like this, my lord. Adjacent landowner also, he'll claim the very same amount.
How much?
Adjacent landowner, he'll also claim the very same amount. That is the
Obviously,
entire
they're
village.
part of the same
This
notification.
is only 8 cents of land is acquired. Maybe around 323 square meter. Adjacent land again 550.
Just say at the request of counsel for the respondent number 1, adjourn 2. There is one thing there, Mr. Bhatt. Lot of difference, what has been there by the LAC and what is being awarded.
In this particular case, if my learned friend can be requested to serve, I'll assist the court.
Yes, yes, he
Just give
he
it
has
a
to take notice, my lord. Note, he has to take notice for respondent number 2 also.
And see, and the reasoning is not on the basis of that's the market value, based on some evidence.
Respondent number 2, my lord. My friend is, yes, tell your respondent number.
Yeah, just give the date, man.
More or he,
What is
whatever
the
he
date?
decided, we have paid that amount also.
Obviously, you will discharge your liability.
9/1/25,
Next,
number 13, Sri Prakash Angadi,
Yes.
13.
Each time may be given to file the deposited amount, my lord. So I'll verify whether it is deposited or not and verify the application. 50% of the-
tell us one thing. This is how is this? What is the ground on which the arbitrator rejected it? Or the learner trial court? On the ground of limitation? How would you come over?
That's
You appear for whom?
Lord, I appear for respondent number
Which respondent?
R1.
Tell us. You may have deposited, but this case, this is, what is the date of this is this? When did you what is the date of the award? And when did you file the appeal?
date of
Impugned award 23/4/19, the suit filed on 10/7/20.
maybe taken next week, my lords. I will deposit amount has been made, my lords, as per this.
Irrelevant. There is no need for deposit. This is a fit case to be rejected.
My lords, next week, my lords, I will, senior is unwell, my lord. That is the reason. And.
Mr. Bhatt, just see that, under 34(2)(3), he rejected that it's a barred by time. No, the 3 months and 30 days.
There is section 5 of the Limitation Act does not apply at all.
That's all. So,
Settled
but,
orders.
so, and that's what he did, the learned judge. He rejected it. Okay.
There is
When do you want?
3 months and a grace period of 90 days, 30 days. Beyond that, there is nothing.
And annexure B is the, my lords, translated copy has to be filed, my lord. 2 weeks time only. Kindly pray for 2 weeks time.
We'll have it next week. Get ready.
Yes.
Okay? Re-notify next week.
21/11. 14. Serial number 14, Sri Satish.
Appearing for appellant hearing, my lord.
Report the respondent number 2, NHA, my lord.
This
Delay of
appeal,
19 days.
this appeal is filed for to remand the for press consideration to enhance the compensation of this appellant, my lord. The appellant spent rupees 1,65 lakhs claimed and 65 lakhs claimed spent for construction of his oil mill and building for conversion of land and other expenses, my lord. And he also lost his business and he is a senior citizen. Hence, the lower court is not considered his value. So herein produce the documents to showing that he is having building, my lord. That has not been considered by the arbitrator while evaluating the compensation amount to the appellant, my lord.
Let's see what does the arbitrator say.
Yes.
You ready? Argue?
Copy.
Next, there is a delay of 19 days, my lord. Due to the appellant was a senior citizen, he was not well. So that is the
Posted
reason.
for hearing, my lord. That delay, I have no objection. Delay, I have no objection. It may consider for final hearing next statement.
So like that 90 days delay,
19. 19.
we'll condone it. But what is the case on merit?
Yes, my lord, this is my, yes.
Copy.
You have not challenged it.
We are not, we have accepted, we have paid that enhanced compensation also.
So enhanced compensation is now 66,360,
No, 75 lakhs, sir.
74,75.
Yes, yes, my lord.
They are paid.
That also,
Yeah,
paid.
paid.
That also paid.
Then what remains?
I am asking for enhancement of, he claimed 1 crore 65 lakhs.
See, we can't enhance.
It may be referred
For
for,
in 34 jurisdiction.
it may be referred for arbitrator, my lord. Arbitrator will.
Oh, nothing doing.
This is third round
This
of,
is a law.
second round of litigation. Earlier MFA filed on the ground of limitation that honorable arbitrator rejected the claim of the petition. After that, this honorable court considered and remitted back for fresh consideration. They have got all opportunity to file his documents and everything. After that, this is the order. That amount also we paid.
Previously, I prepared a pay, OS arbitration suit, before district court. The court held that there is a delay, hence my delay application is rejected.
That is over now.
Yes, my lord.
Now this is a determined.
Thereafter, it is remanded to the district court. The district court again passed the order. So you have no merits, hence cannot be referred for arbitrator. That is the order of the district court.
So what do you say? What is wrong in that?
My lord, he has a building, hotel, business, and
He has
converted
considered
land.
everything.
That has not been considered.
He has considered everything.
And 65 lakhs.
4 coconut trees, teak trees, 1 nandi tree, with solatium, additional market value, 9% interest. That is
That
another
has
new
not-
act.
He spent 65 lakhs for construction of building. The court, the arbitrator considered.
When did he construct the building?
Recently is constructed and
Recently when?
next state.
Where is the ground? Just show your appeal.
Acquisition pertain to 2014, my lord. After that, they cannot construct also.
Where do they say that they have constructed?
No document. has been-
And does this plea, was this plea taken below?
No, man.
That
Did
The
you take
thing
this
is-
plea below?
I taken.
Where is that? Show us.
Statement is there. no? Statement must.
Just 2 pages appeal, simple appeal. Where did you plead? Where did he plead? Does he plead there before the court below?
Yes, my lord. I furnished all documents, photos.
Okay,
before-
when did you construct?
These are photos I produced before the lower court.
Oh, photos
That
would be there. Photo doesn't mean that you are entitled to.
And receipt and other documents, my lord. That has not been considered by the lawyer. These are building photos, my lord. Those are all furnished in the lower court. Those not considered by the law. Here in photos, everything is
Okay.
furnished, my lord. But that has not been considered by.
Has he filed that 34 petition on record? Is 34 petition there on record?
For petition, he has not filed. He has filed only orders that pleadings are not submitted. So record also not forthcoming. If you bring that record, so that otherwise I'll only secure record.
No case.
Record may be called for. Record may be called for, it will be.
No need, we will not, you should have pleaded. We will not do this exercise.
Let him file documents along with memo, my lord. On next date of hearing, I'll also be that.
What memo? See, you should have also seen it.
Yes, my lord, I saw that, but I had to secure from Mangalore.
Now a new case is ought to be set up. It appears.
Yes, my lord.
No, he has considered it, page 10.
Generally for building, my lord, even SLO or arbitrators so liberal for granting compensation. They are also aware that in sale deed, lesser amount will be mentioned while executing sale deed.
What is this on careful examination of the compensation assessment sheet? Award land acquisition officer has assessed the entire building and also awarded compensation for this.
That
They applied 100% solution.
that building valuation will be done by the approved registered government valuer. Based on his opinion, they'll make the payment. That is not under dispute. That registration is not correct or we have valued ourselves, something like that.
See, under 34, we can't tinker with the compensation.
Maximum, this honorable court has to remit back. Already remitted back. After that also, they have not produced any document.
Before we can't remit, that's the law.
Yes, my lord.
37 rather. What shall we do?
In
no
the
merit.
in the arbitration suit, the appellant has filed a estimated building with sketch, private engineer, estimation along with the estimation of residential building with sketch prepared by private engineer and the loan sanction letter, all those things is produced in the arbitration suit, my lord. Those documents. The call, record may be called for, he has produced all documents.
Then why didn't you file it?
Those documents with the lower court, my. While he filed in the arbitration suit, that records may be called for.
What are the documents you have filed?
I filed a document number in arbitration suit, voucher for payment of compensation, possession certificate, indemnity bond, old license for running a flour mill, coconut oil and hotel, estimated building with sketch by private engineer, which is situated in survey number 25 2 B1 in 384.65 square meter. Seventh one, estimation of residential building with sketch prepared by private engineer, which is situated in survey number 25/1 B1 202.35 square meter. Eighth is CC of RTC, ninth is CC of loan documents awarded by the plaintiff, that is appellant, my lord. And tenth is CC of photographs of old building situated in survey number 25 2 B1 384.64 square feet, my lord.
Where is the arbitrator record?
Record. With the arbitrator only.
You would have, Mr. Bhatt?
I'd have it to the office, my lord, but he
Copy
needs
also.
to serve me so that I can take instructions.
Let a copy of the appeal be served on the counsel appearing for respondent number
R1.
2 and 3. No.
R1.
3. No, R1. R1. The record pertaining to the arbitration be produced by the counsel for the respondent number 1 on the next date of hearing. Re-notify on.
Along with the records may be called for, my lord, in arbitration suit. Records may be called for.
Record that.
You have called for, he will produce it.
27, 11,
Arbitration suit, I filed the documents, that the documents.
Let him get it.
Much of.
27, 11.
28 or 26.
27.
Maybe first week or second week of December would be.
Yes, they, whatever is there.
10, 12,
Much of.
15 urgent, 16, Sri Sangamesh. 16.
Yes.
What's the petition is arising out of arbitral proceedings?
Where, my lords, the learned arbitrator, my lords, page 48.
Yes.
Lords, the learned arbitrator, my lords, has directed, lords, the present appellant was the respondent before the arbitrator tribunal. The learned arbitrator, my lords, has directed to refund the advance paid by the respondent in a sum of rupees 13,10,000 along with the interest at the rate of 18%. Along with interest at the rate of 18%, notes. What's challenging that, notes, proceedings were initiated before the principal district judge, Mysore, notes, in arbitration suit number 4 of 2013. Notes, this arbitration suit was also dismissed on 31st August 2015, notes, confirming the order passed by the learned arbitrator. But in the last occasion I submitted, I will consult my client, and a portion of the amount has already been paid to them. I'll consult my client regarding I am told that lords about 9 lakhs rupees has been paid.
How much is the balance?
9.5 lakhs is paid, my lord, during 2018. My lord, the principal amount is 13 lakhs plus 18% interest from 2007. My lord, that.
I tried to contact lords, he's not responding. Therefore, I would request this, lords, I would request this. Your lordships may pass orders, lords, confirming the order, because I've become
See,
so.
we have gone through it, Mr.
Yes,
Sir.
yes. That's why lords, I don't want to say anything unless I was only anticipating, lords,
And
if
we
I
are
can
in
reduce an
34.
interest from 18 to either 12% or so. If my lords, even that, my
We
lords,
are in 34 June. And just imagine, when was the due and payable?
yes.
2007.
2000, as per the arbitral award notes, the payment was received in 2007, lords.
Just imagine.
Yeah, I understand, my lords. I am, I tried to see that, my lords, the dispute get resolved, but then,
And adding to all this, my lord, I'm told.
Was this 18% otherwise a contractual amount, contractual interest?
let's see, it is a advance amount paid by him to me for the purpose of in the sale of an apartment, my lords. I'm a builder.
That's
I
right.
wanted to.
And see, that's the point. And he is the person who wanted to
Purchase the apartment. But then my allegation is that he did not pay the balance amount in time. Therefore, I have forfeited that. Nevertheless, lords, the arbitrator held I don't have the right to forfeit. I am required to pay that advance
My
amount.
lord, I opted for a particular unit. My lord, without notice to me.
He changed it.
He changed it. And
Yes.
my unit was sold to someone else.
He opted for a ground floor unit. Lords, his allegation is that I have changed it to the second floor. Then he says he doesn't want that second floor. Then the advance was lying with me, lords. The arbitrator directed to refund that. I would therefore, lords, not argue much and waste more time on this. The honorable court, lords, precious time. Your lordships,
Very well.
lords.
9.5 lakhs was paid in execution proceedings in
Then we
2000.
will dismiss this.
Your lordships may dismiss it.
Okay, we'll pass orders.
Very well.
Reasons to follow, we'll dismiss this. Okay, thank you. Please.
I'm obliged. The lordships may note that the portion of the amount has been paid as per the
9.5
submissions
lakhs
made.
paid during 2008.
How much?
2018,
Because
9.5
that
lakhs.
is not there in any of the records, lords.
Ma'am, we'll just pass the order here. Where is the order of the court below?
Lords, the learned arbitrators order award is at page 22, my lords.
That's right. Where is the challenge under 34?
34 is page 12, my lords.
12.
AS4 of 2013.
These are all the, why are we not getting 12? Same order, just show us the file.
Scanning, there might be a mistake in this.
Just say the challenge in this appeal under section 37 of the Arbitration and Conciliation Act 1996 is to an order dated 31st August 2015 passed by the Court of Principal Districts and Sessions Judge Mysuru on a petition filed under section 34 of the Arbitration and Conciliation Act, challenging the award dated 22/4/2013 has been rejected. What is CMP?
Well, it's CMP civil miscellaneous petition.
Where
Under
was it
11.6.
That is for the purpose of appointment of arbitrator, lords, under section 11 of the.
Full stop. Some of the facts which are required to be noted are the respondent who was the claimant, before the learned arbitrator, respondent before the sessions judge had entered into a agreement with the appellant, agreement of sale with the appellant in respect of a residential flat bearing number G-1 on the ground floor, having built-up area of 1,700 square feet, along with the undivided interest of 656 square feet in the whole property for a consideration of 29 lakhs. To stop. The case of the respondent before the learned arbitrator was that the appellant had unilaterally changed the flat from G1 to G3. Full stop. The appellant had also failed to furnish necessary khata certificate from an approved building plan to enable the respondent avail the finance of rupees 30,97,900 from the ICICI Bank. Full stop. Despite that, the respondent had paid an amount of 10 lakhs on 13/10/2007. In addition to 3,10,000, which was paid in advance in the first week, which was paid in advance. Full stop. The case of the appellant was the respondent had failed to pay the installment as agreed. Therefore, the allotment had to be cancelled. Full stop. He also claimed that still to maintain cordiality, he allotted flat number S1.
Second.
Pratham Jayalakshmi NXC project. Full stop. In the above background, disputes having arisen on an appointment of the arbitrator made by this court, the arbitral tribunal was constituted, and the disputes inter se parties were referred to the adjudication by the arbitral tribunal of a sole arbitrator. Full stop. The reliefs claimed by the respondent before the arbitral tribunal were the following: page 14, 1, 2, 3, 4. Tick to tick. Full stop. The arbitrator, in terms of the impugned award, upheld the contention of the respondent by holding that the respondent by holding the appellant is guilty of breach of agreement. Full stop. The arbitral tribunal passed an award granting the alternative relief of refund of 13,10,000 with interest at the rate of 18% per annum and costs of the proceedings. Full stop. Next, the award was challenged by the appellant under section 34 before the sessions judge by primarily stating as under para 4, page 15, tick to tick. Full stop. The learned sessions judge framed the following points for the determination. 1, whether the impugned award calls for interference under section 34 of the Arbitration and Conciliation Act 1996. 2, if so, what order? Suffice it to state that the point number 1 was decided in negative, was held in negative, and point number 2 was held in negative. The reasoning given by the learned sessions judge can be seen from paragraph 10 and 11. Paragraph 10 and 11. Stop. It may also be stated, the learned sessions judge has by noting the scope of section 34 of the Arbitration and Conciliation Act, held that the award passed by the learned arbitrator cannot be interfered with. Full stop. the paragraph 11 of the impugned order of the sessions judge is by noting the finding of fact by the learned arbitrator. In as much as that the respondent made all efforts to perform and materialize his part of the contract. And in fact, it is the appellant who failed to perform the contract on his part. Full stop. It is based on this, the full stop. The said conclusion of the learned arbitrator can be seen from paragraph 11 of the award at page 39 of the paper book. Wherein X66, wherein the learned arbitrator held as under. Just say page 39 and 40, tick to tick. Even on issue number 2 and 3, as framed by the learned arbitrator, which are said, just say whether the claimant proves that respondent breached the terms of the agreement dated 29/3/2007. Then 3, whether the respondent proves that the claimant breached the terms of agreement dated 29/3/2007, and therefore the allotment of G3 apartment in favor of the claimant was rightly and validly cancelled. As held the following, as held as under. Just say this, as held, inter-alia held, that under these quote, X66 quote, under these circumstances, it is impossible to hold that either there was a proper and valid cancellation of allotment of G3 apartment in favor of the claimant, or there was any legal termination of the contract between the claimant and the respondent. Quote close. For the aforesaid, by giving aforesaid conclusion, the question number, issue number 2 and 3 were held, 2 was held in affirmative and 3 in the negative. Full stop. It is on the basis, next para, it is on the basis of the aforesaid conclusion. The arbitral award, the conclusion, the arbitrator has allowed the refund of the amount of 13,10,000 by stating as under page 15 tick to tick. Stop. Suffice to state, the aforesaid, suffice to state, we agree with the conclusion drawn by the sessions judge in paragraph 5, wherein it was held that wherein the arbitrator has discussed elaborately the evidence on the basis of which he had come to the conclusion that the appellant had failed to perform his part of the contract. And the respondent was also always ready and willing to perform his part of the contract. To stop. The conclusion, the basis on which the learned arbitrator has awarded the amount in favor of the respondent is primarily based on a finding of fact. And the law, as noted by the learned sessions judge, more particularly with regard to the scope of interference in a petition under section 34 of the Arbitration and Conciliation Act, being limited, no interference is called for with the impugned award. Full stop. With the impugned award. Full stop. And there is further, there is no, it can further, since this court is exercising the jurisdiction under section 37, a similar would be the scope of judicial review. Judicial review in a challenge made to an order passed under section 34. In section 34, before us under section 37 of the Arbitration and Conciliation Act. Full stop. We in the facts of this case, and the elaborate and the detailed award passed by the learned arbitrator, which has been rightly upheld by the learned sessions judge, we are of the view that no interference is called for with the impugned order. We'll stop. We take on record this submission made by the counsel for the appellant. How much you have given?
9.5 lakhs.
Just
Total 9.5 lakhs on
figure.
various dates, my
My
lord.
lord, on different dates, in 2018, I have the dates.
We take on record the submission made by the learned counsel for the respondent that the appellant has till date, against the award, against the benefits granted to the respondent in terms of the award, has paid an amount of 9,50,000 in all on different occasions. Full stop. Full stop. That's all. Thank you.
Very, very. We are obliged. May I submit the details of those payments, my lords, if the lordship permits?
We have said so in all on different occasions.
Very well.
But it's a round figure.
It's a
950 is a round
Yes,
figure.
yes. Yes.
We're just only saying it for the purpose of record, that's all. That's the reason we have noted his.
That may arise, all these dates and calculations in the execution in
Execution.
case they go. Obliged.
17, seal number 17.
Appear for the appellant in this case, my lord.
Yes.
The present appeal arises from a suit for recovery of money filed by the respondent, which is OS number 571 of 2021. The nature of transaction was that in Uttar Pradesh, I was awarded a certain contract for the purchase of solar power. I had appointed the respondent as a quality inspector, in furtherance of which there were certain purchase orders placed. Now, subsequent to this transaction, the order by the UP government itself was cancelled. Hence, I was forced to terminate the contract. And in fact, over a series of email exchange, has been informed that this has happened, and they have responded saying, please provide the documentation to pay off the pending amount. Despite the documents being provided, a suit was filed in Bangalore, which came to be decreed ex parte.
The basis of the claim of pending amount is the purchase order in email correspondence, but the documents provide show that this is disputed itself. So I have three submissions to make on this aspect. First and foremost is an ex-parte judgment. The notice was served by way of paper publication. The respondent, the appellant and the defendant before the lower court was unaware of the present proceedings at all. Subsequent to which the present appeal has been filed, the matter has been stayed, subject to
What
deposit.
about the second submission?
The first is the ex-parte. The second submission is the amount is not due in light of the fact that the government order itself was cancelled. My request, Your Honor, to kindly have a look at page 37, my lord. That is a typed copy of official memorandum wherein the purchase agreement of 2015 was cancelled with immediate effect. Page 37, my lord, typed copy. Annexure D. The typed copy is at page 37. As per approval granted by Chairman UPCL Shakti Bhavan Lucknow in compliance to order dated 12th February 2018 of Honorable UPERC and consent given by Mrs. Authorized Energy Private Limited Lucknow, the power purchase agreement executed on dated 3rd of December 2015 for purchase of 5 megawatt solar power is hereby cancelled with immediate effect. This is the cancellation, my lord. This has been initiated in Annexure E, intimated to the respondent. Annexure E is the series of email exchange between the applicant and the respondents. I'm relying on page 42, my lord.
This was to you.
To me, my lord. My contract with the UP government was terminated, and in furtherance of this is they were appointed as a quality inspector, my lord, owner's engineer. My lord, may kindly see page 42. There's an email dated
You
June.
appointed him as a quality inspector?
Yes, my lord. And the appointment was by way of Annexure A, Annexure B, my lord, wherein there was a.
But why did they terminate?
The tariff changed, my lord. The tariff became incompatible. They had the issue with regards to
Did not make a claim with the UP government?
No, my lord. The thing is, the amount that was there for the purchase, I have referred to it in my appeal memorandum, my lord. This is at page. There's a issue with regards to the amount, my lord, which they had given for it. But this is what the reason is, my lord. The third submission, my lord, is with regards to a prior intimation, my lord, at Annexure E, my lord. My lord, may kindly see page 42. It's an email dated June 7, 2018. Dear Nitin, we were the owners engineers for Avatharaj 5 megawatt solar project. We came to know that Avatharaj is backed out from the project due to revised tariff. This is the one, my lord. We invoiced 41 of our work and we received 11 PIs. Provide some document that you have backed up from project to waive off our pending payment. This is the email sent by the respondent, my lord, TUP Rainline India Private Limited. None of these aspects could have been considered by the trial court because I was placed ex-parte, my lord. So in summary, my lord, three submissions are ex-parte judgment, wherein I could not lead my defense. Second aspect is the basis of the entire transaction being a project issued by UP government was cancelled because of revised tariff. And third thing, I've intimated to them at the earliest instance, owing to which they have said that provided documents will waive the payment off. I realize my limitation, my lord, since we are in the appeal.
Submission, what did you say?
The third is that they themselves have said that we'll waive the payment, my lord. The email dated June 7, 2018 categorically says that provide documents that you have backed up from project to waive off our pending payment. So the way it works is that we have already paid them 1 lakh at the time of the commencement of the project. There were invoices that were raised. So they asked us to.
Where is the contract?
It was basis of purchase order. Annexure B was there.
The purchase order.
Annexure B was there. Annexure C is the purchase order, my lord. That is 8th August 2016, page 34, my lord. Third-party inspection to carry out owners engineers for 5 megawatt solar capacity power plant in Uttar Pradesh, India. The total quantum of the entire work was 7 lakhs, of which admittedly 1 lakh has been paid initially. Now they had further raised invoices for a sum of 3.5 lakh.
But why did you make claim for only 4 lakhs?
That was a pending amount, my lords. Some of the amounts were waived off to them.
So
Typically it was 7 lakhs, my lords. They had made some payments and balance. We had only claimed 3 lakhs 9,266 as a principal and 96,000 as an interest way back in the year 2019. Suit was filed in the year 2019. Summons was served from the rural court, sent from the rural court, and the address mentioned in the cost title before the trial court and address mentioned before this honorable court is one and the same. There's no change in the address.
What were
And the
what-
transaction was of the year 2016. They claim that PPA was cancelled in the year 2018. By that time, my lord's invoice was already raised, work was already completed.
Come again, what did you say?
Lord's 2016 was the transaction. Work was completed by us. They
What
cancelled.
was completed by you?
Yes, my lords. They say that cancellation is of the year 2018. They have issued the work order in 2016.
The UP government cancelled in 2018.
18.
For 2 years, you carried out your work.
We have carried out. For that, we have raised.
Where is the finding on this?
Let's see if my lords were to kindly take page number 14, my lords, of the order. Page number 13, last paragraphs.
The defendant company approached the plaintiff with a request to conduct.
Conducting third party inspection to carry out the original engineers 5
Engineer
megawatts
completed the
solar
work
PV
assigned as
power
per the
plant, so
order.
and so, dated 18/8/2016. We have completed our work and now.
Do you dispute this?
Lord, yes, my lord. The reason I'm saying is because the entire work was 7 lakhs. As and when there is the invoices, they make the payment. The invoice itself was raised for just 4.5 lakhs, my lord. The invoice was raised by them itself. That finding is there in the low court, my lord. The invoice that has been raised by them itself was for sum of 4 lakh 9,000 something, in which 1 lakh has been paid.
For which work we have done, we have raised the invoice.
So the work according to them itself and the invoices produced was for 4 lakh 9,266, my lord. And in that 1 lakh was paid. Subsequent to the cancellation by the UP government, there was for the work
When
that
was
was
it
done.
cancelled?
The change in tariff was the reason why UP government,
That's a finding of fact, and
which,
that's a letter of 2018.
true, my lord. Now, because of the ex-parte judgment, I could not produce any of this before.
He said nothing on that. Let's be very clear. What is the ground for being ex parte? Is it your case? Notice was not, summons were
Yes,
not
my lord.
served?
That is at my ground, my lord. Now that I was unaware of the proceedings, and in fact, Your Honor would see that the manner summons was served was by paper application, my lord. Your Honor could kindly see at page 16.
Well, we will not take this. See, this is something. And the submission is, otherwise we'll call for the record, we will see it. If you see that everything was the same, what is the address ought to be
Address
given?
is, it's a paper publication. The notice was not served, my lord. That is the aspect, my lord. And
But publication is a subsequent event. Before that, attempts were made to serve you on that, on the address.
yes, my lord. May I just submit, my lord? This is a fit case for it to be remanded back to the lower court with regards to having.
We
the
will
finding
not
of
on
fact.
this finding of fact, surely not.
Because,
This is the finding of fact, and if you are, what is the stand you have taken in your appeal?
I have taken 3 stands, my lord. One is with regards to it being ex parte. I was unaware of proceedings. I could not produce any of these emails and cancellation, my lord. Second and foremost is that the email correspondence between the parties themselves suggest that they have offered, you please provide us documents and we will waive the payment.
He's saying he's waived off.
No,
Obviously,
My claim is
That's what he's
for
saying.
4.9 lakh,
as
4.9.
against a contractual amount of 7 lakhs.
We
what
have,
that
they've never
pay-
carried out work for 7 lakhs, my lord.
Pardon?
They've never carried out work for 7 lakhs.
Right. 7 lakhs, they did not carry out, 1 lakh advance. They made a claim initially for 4 lakhs odd. Now they confine themselves in the suit for 3 lakhs odd.
My lord, the 1 lakh payment is not disputed. What I'm saying is that for the invoices that they have raised, my lord, they've said that we are going to waive the payment. It's for the email that has been provided by them. By the party that who has filed the suit, then they should make the provided.
There is your ground that they did not, after the issuance of this purchase order, no steps were taken because by the time the cancellation had come from the UP government. Where is that ground?
Lord, I could not take any ground before the local because I was ex parte. Over here, I've taken the ground
Where is
that
the, you show us here. You show us here.
subsequent to the cancellation of the project by the UP government, my lord, what steps I have taken is I've informed them that this is the reason why this particular transit has happened.
At least what we have understood till now. The impression which we are getting from you is purchase order. Before the purchase order could be acted upon, there is a cancellation from UP government.
No, my lord, the purchase order that has been,
We are getting.
no, my lord, the purchase orders of 2016.
That's right.
Yes, my lord.
Purchase
And-
order issued, before it can be acted upon, the cancellation has come from UP government.
That might not be what I was trying to say, my lord.
Very
I
good. So-
apologize if that has what come across.
Now tell us,
Yes,
if
ma'am.
that is not the position,
Yes, madam.
did the purchase order, was the purchase order acted upon?
Yes, partially, my lord.
Partially,
Partially, my lord. So in
not for
accordance with
7
payment
lakhs?
in payment also has been made for 1 lakh,
How much?
1 lakh, my lord, which is not in dispute.
How did you make the payment for 1 lakh?
I'm unaware of that, my lord.
We will show you.
May
Come to the
make a
purchase
request
The
order.
lower
come to the purchase order.
My lord is referring to the breakup
Page
provided, my
number-
lord, 20%, 50% breakup, my lord.
May I request page number 43, my lords?
Yes.
The advance 30% should be paid before the project. That's not, my lord.
Page
Page
number
35.
43, the email correspondence which they have agreed to clear the outstanding payment.
No, that pertains to travel expenses, my lord. That's a very different. The entire reference that is made is with regards to the service charges and the travel costs in those context, my lord. It is a very selective reading of
Kindly
this.
see page number 44,
Page.
44, my lords. There's an email written by us. Let us know the status of our invoice payment.
This is on 12th May, prior to my email
One
cancellation,
minute.
my lord.
Let me complete, sir.
I'm sorry, please. I'm sorry. Go ahead.
Yes, tell us what is 44?
Plus, there's an email dated 12th May 2017. Dear Mr. Aditya, let us know the status of our invoice payment, which has been written by us. If my lords were to kindly take page number 43. Below last mail, my lords, kindly clear our payment at the earliest, my lords.
But the payment, what was the bill?
Invoice amount, my lords.
How much was the invoice?
4,09,000, for
Not
which they have
4,000.
paid only 1 lakh. And kindly at the top, my
Was
lords,
this 1 lakh an advance amount or for the work you have done?
for the work we have done. And sure, top above mail, my lords, dear Mr. Ajay ji, sure, we will get it cleared at the earliest. Kindly clarify if 14% service charges and SP and cess applicability on the travel cost, please. The first part says that, my lords, the invoice would get cleared at the earliest
This is 2017 before
Yes, sir.
cancellation.
before cancellation. And
And what is the date of the invoice?
My lords, 2017,
Where is that invoice, the final invoice, the
my
final
lords,
bill?
invoice was dated, work order was dated 8/8.
No, invoice is not there, my lord. Invoice is not before, my lords. Invoice is not produced, my lord. Yeah.
Invoice was,
Kindly call for the low code records. At least the invoice details would be secured, my lord. That way.
A small matter.
True, my lord. The only thing is
Retain
ex-parte
us.
if I can have.
my lords, if they are ready even now to pay the amount, my lords, I can ask my client to waive up the interest and clear this case.
It's not a fit
Instruction.
case for an appeal.
If the aspect with regards, I'll take instruction from my client. If there's some bimeter that can derive that, my lord. That's all I can.
We'll pass out, take instruction, what
No, my
we
lord,
have
the
said.
parties in UP, my lord. I'll have to write it to them. Can you have it?
You will call from here.
No, my lord. It's a company that's there. Have it on Tuesday, my lord.
No.
May I request?
Nothing going. Get your instructions.
My lord.
We will
Request for
not.
tomorrow at least, my lord.
We
because I
will
feel-
not. A small instruction, he's so fair. He said, I'll waive off the interest. Let's see how much is the interest amount. It must be more than the principal.
No, my lord. 97,000 is interest.
That was claimed in the year 2019.
But till date,
From
you have
that
not
day till
paid it.
today, my lords.
No, 1 lakh was paid, which is admitted. That
The
will-
remaining amount you have to still to pay. The interest would accrue
I'll take instruction on that aspect.
Do that.
Could it be taken up tomorrow, my lord?
tomorrow. Oh,
Regards to.
tomorrow. To enable the counsel for the appellant to take instructions.
4 lakhs,
You
5.
have heard him. What did he say? We take it, your submission, principal amount be paid, minus the interest.
4 lakhs, 5,451 with interest at the rate of 12% is the order.
No, my lord, 3,57,000. I'm sorry, that's not the entire amount that is there,
This
including the
excludes
interest.
or the
Including
excluded
97,000
1 lakh
interest.
Include.
Includes
It is
the interest
excluded.
component.
1 lakh is excluded. We have claimed only 3 lakhs plus interest till date 2019 was 93,000, my lords. Now the interest, if we
Kindly see
calculate
page
from
15, my lord.
2019, from the date of filing the suit till today, it will be more than that, more than 6 to 7 lakhs.
Let's be just clear on this, my lord. Page 15 of the order clearly provides for 3,09,266 as a principal amount. Page 15, my lord. The interest is 96.
Operative portion, my lords, my kindly see.
That was
My
my
friend is
claim
not
made.
reading the operative portion. Page
In light
number
of
30
that,
23
this
is the
4-5
operative.
includes 9% interest also, my lord. That's why I'm saying that. The
So you want us to hear the matter finally, we'll decide it.
I'll take instructions on it now because I'm not in a position to have.
Take
regards to that.
instructions tomorrow, we'll have it tomorrow. Okay? Yes, tomorrow. That's right.
I have-
What? Please express yourself.
Very well, my lord. I'll have instructions.
You want to have tomorrow?
The only reason I'm saying that is because if the aspect of records have to be seen and everything, that they could be called for, or if my mall wants.
You have to make out a case for calling of the record. Let's be, we are in first appeal,
We
we are
cannot
no, we are
have-
conscious.
I understand, my lord. My only.
Purely not on this.
Yes, my lord. The reason I'm saying
And
that
we
is,
will do one thing. We will call for the record. If we find ultimately notice served, still you did not appear or for whatever reasons, then we will take it to logical end.
I understand the risk I take. The only reason is
We'll
ex-parte
take it. We
judgment
have
is
no
why.
issue on this.
Because my entire premise of the filing of the appeal was an ex-parte judgment, wherein this is also show my matter on merits.
First thing you should have gone is file under order 913. The trial court would have seen. These are the grounds which have been taken. And this is the reason why they were ex-parte. There was a genuine reason, they will set aside and they'll proceed with the suit. That's the procedure should have been taken. We don't mind.
May I just seek
Very
one
well,
indulgence?
very well.
my lord?
We'll
May I
call
seek
for the record.
No, very well,
Please.
my lord. I'll take instructions.
We'll
like-
call for the record.
May I just submit, my lord, if it's a matter with regards to the principal amount which has been submitted by the council, let me just instruction. May I seek for one indulgence, my lord, since the client is, would have it on Tuesday, my lord. I'll take second instructions. and have it on Tuesday on the aspect of the principal amount and what they will include.
Right, he's being saying.
Very well, my lord. I'm grateful for the indulgence. Kindly have it.
Yeah, next Tuesday.
Grateful.
1911,
My,
serial number 18 and 19 adjourned, 20, Shreyas Jayasimha. Serial number 20.
My lords, in this matter, the Honorable Supreme Court has passed an order on 30th of September. My learned colleague is presenting that to the court, that may kindly be taken on record. In terms thereof, at para 13, clause 5, the Honorable Supreme Court has in fact disposed of this current MFA. It said that MFA 3240 filed before the High Court of Karnataka shall stand disposed of. And they have directed the Honorable Trial Court to consider the 34 application afresh. And that is the order that has been passed by the Honorable Court.
Oh, 37 revived, 34 revived.
34 has been fully revived, correct. I only request that this may be kindly taken on record and the records may be kindly returned to the trial court. I am grateful.
Is anyone appearing for the other side?
Yes.
Bharat.
Were they represented before the Supreme Court?
Yes, yes. You will see, my lord, at the last page, there are 4 counsel.
Yes.
It is after they were fully heard, and then after this, the order was passed. I'm grateful.
Just say this. The and do we have the file? Let's give the file. Is the number 20? 20. Just say this, learner counsel for the appellant has filed a memo before the court today, which reads as under. Stop. Along with the memo annexes an order dated 30th September 2024, passed by the Honorable Supreme Court in a civil leave to appeal civil number, special leave to appeal civil number 22946 of 2024. The vide the said order. The
For the respondent in this matter.
you appear for respondent.
Yes.
The Supreme Court, on the basis of consent given by the counsel for the parties had passed the following order. Just say it, paragraph 13. Full stop. The yeah, this is say small Roman 5, huh? From small Roman 5 above, it is noted that the Supreme Court has disposed of the present MFA 3240 of 2020. As the Supreme Court has restored the petition under section 34 before on the file of 20th additional city civil and sessions judge Bengaluru. Full stop. You agree, you have seen this?
Please, my lords.
Full stop. In view of the aforesaid position, comma, in view of the order of the Supreme Court, comma, the present appeal is closed.
Grateful. And the records may kindly be directed to be made available so we can take it to the trial
The
court.
record was sent here. It is here. Full stop. Just show us which is the record. What is the, no, just show us which is the record had come, which petition record.
Arbitration suit number 191 of 2017.
Just show us that. Just say this, the record of the arbitration suit number 191 of 2017, which has been sent to this court, shall be sent back to the court of 20th additional city civil and sessions judge at Bengaluru forthwith. Okay.
Most grateful.
Publish.
Twenty-one, Shantesh Bhagat. 21.
In this for the appellant, my lord.
You're ready?
No,
Hear
my
you.
lord, morning, my lord.
Very. How many times you have taken it, June?
My lord, I have taken, my lord.
We'll give you a short date, but you must be ready.
Yes, my lord.
We'll give you next week. Just say that at the request of counsel for the appellant, re-notify. Just give next week.
20th.
Sir, 20th, 22nd or 23rd?
Just give it.
22/11.
Please, ma'am.
Great.
22 Arjun. 23 Shivani Krishnan.
Inform that this is a settlement in the parties, my lord. The Union of India and my lord, the respondent, this is settlement. That's what is informed by the council. Yes. It doesn't matter.
You have settled?
That's what he says, my lord.
You don't have any idea?
I don't have any idea, but
You
he
appear
says
for R1.
R1. The first matter, I am the appellant.
Who is the counsel for union? Mr.
I am
Oki?
for the.
Oh, I'm sorry. Ajay, you are appearing for the appellant.
Yes.
You have no instructions.
Instruction, but I was
Who is
informed by
the counsel for the respondent?
Mr. Girish, who has also challenged the same order.
But can you check up? We'll pass over.
I can do some. I don't have his number, but in fact, I met him once last week. He said matter is settled. Probably that's why he's not come.
You show us. No. See, one thing is there is a cross objections also.
Yes.
That cross objection, there is a memo. Acha, this is Vivad se Vishwas to in
Yes,
relation.
yes.
You have this memo?
I don't have the
Yes,
memo.
just show us the memo.
He said under a scheme, he got it settled. That is what I was informed.
That's right. He want to take the benefit of the scheme for which you have put a condition that you have to withdraw the dispute.
Yes. Probably that's right.
It's like this.
Yes, yes, yes.
He has filed cross objection. He has,
Mhm.
the other is you have filed it.
Yes.
Now what will you do?
My lord, if matter is settled, my lord,
Then possibly you'll withdraw
I'll
this.
withdraw.
He has withdrawn his objections.
Yes, my lord. Then I think I will also, next week I'll withdraw mine also. I'll seek instruction, I'll withdraw. I'm also informed that he was also awarded new contract subsequently. So they seem to have ironed out all the differences. That is why,
Just say this. No, shall we just re-notify the matter for you to take instructions?
yes,
Since-
yes.
Technically, his objections are not withdrawn, allowed to be withdrawn till such time we pass an order.
Yes,
But he has filed a memo.
that to withdraw it because he
to
wants to
withdraw
take
it.
the
At least
benefit.
he has
under-
expressed
You are-
himself to withdraw it.
Yes.
Just check up. If they have at least given the benefit or settled it.
Monday, my lord, I will.
And you also take instruction what will happen to your appeal in terms of the settlement.
Yes.
At the request of counsel for the appellant, Mr. Unnikrishnan, re-notify.
1911. Twenty-four urgent, 25, Shri Prashant Chandra. Serial number 25.
Appellate may be. But in this matter, I request a short accommodation. My lord. In fact, yesterday late it was listed.
Sir.
even though I am
Pardon?
appearing for the respondent. It
Appellant.
may be taken up on the same day, may not other matter, 22nd or 23rd.
May I request?
You will have it now what? Submissions have to be filed?
Synopsis is filed.
Filed?
Yes,
All in all the appeals?
yes. It's all arising out of two appeals, two consolidated appeals. which
How
are-
long it would take?
According to me, not much of time, but it may be about 30 minutes from my side.
Just say this, the request of counsel for the appellant re-note, give in December or January. January also you can give.
8/1/25,
Please.
26, Srimati Shilpa Shah.
You said what?
Appellant in this
26.
matter.
Yeah.
I appear for the appellant in this matter.
For the respondents.
Yes.
Here, my lord,
We'll just pass over, ma'am. We'll come back. Please, just pass over.
we will have some difficulty in the afternoon. You will not-
We'll see. There are not many matters left now.
Please.
27,
Yes.
Landlord and tenant, my lord. My only request to your lordship is, I bound to honor the orders of the honorable court. I have never refused to, my lord, pay the security amount even before the trial court, my lord. He did not offer the key, he has resisted not to hand over the key to me, therefore I could not deposit. my lord.
See, best should be, like,
Please, my lord.
take the key from one hand and give the refund from the other, or the balance amount.
Yes,
That should
ma'am.
have been done.
That should have been done
But the way the learned judge has observed.
Yes.
He formed an opinion.
Yes.
That you also never wanted to refund it.
No, I even now I'm ready. I definitely I'm not declined, my lord. It's my
But that's the
obligation.
that's the finding. We say nothing.
Please,
That's the finding.
Please, my lords.
Appropriate should have been, you are getting your property back. He says, I want my whatever security amount which I have given, give me back. That's all.
Please, my lord.
But that has not done.
That is not.
That has not happened.
Please,
And your suit is pending there.
please. Now, my lord, may I request your lordship that I am ready to deposit before the trial court, whatever the amount, so that I can honor the honorable court's judgment. Let the trial will go. If he succeeds, let him take.
Who appears for the respondent?
Even two occasions he has not appeared.
I have informed yesterday.
Please, Mr.
Yesterday, I informed the
Yes,
Dushyanth.
Who is the counsel? Dushyant.
Mr. Dushyant. To the extent, Millard, I may be permitted to file the memo so that your lordship can dispose.
What you say is, you decretal amount you will deposit in the court.
Below, please. So I will show my bona fides. At all time, I am ready.
No, with that.
So without influencing the judgment, let the court decide the matter.
See, intercept, see, it's like this. Between both of you on an issue on merit, it's conclusive. Your difficulty is this finding will come against you in the suit which is pending.
Exactly.
Till such time, we can't say that dehose this or overlooking this without being influenced by this, that should be decided. We can't say so. We need to take a call insofar as this finding is concerned. If it is a finding in your favor, it will inure to your benefit. If it is against you,
yes,
that's the end of it there.
Now, my lord, even the finding, my lord, he has not, my lord, produced any acknowledgement for having delivered that point was not considered. No document was produced. My lord, no evidence was produced for having shown that he has delivered possession and added over the key. Admittedly, the key is in the honorable court, and the court has directed the office to give it back to the tenant himself, my lord. In that event, my lord, the key has not been given possession. That's my.
But that's on a finding that you refuse to give the money. You refuse to give the money.
No, my lord, not in that case, my lord. There are two cases, my lord, two instances wherein in the trial court, where IA number 3 was rejected, in that order, there is an observation and direction given to the office to give the key to the. Subsequently, my lord, the case was transferred to the, my lord, the commercial court. In that aspect was not considered. So, taking, my lord, the aid and the advice of the honorable court, I filed a fresh suit terminating the tenancy. Therefore, my lord, since he has not delivered the key, not possession, my lord, that issue is pending before the trial court, my lord. Therefore, I'm only and I will request you, lordship, please, and I'm ready to deposit. There also, every stage also, I'm bound to do it. But my lord, I have to take my possession and the key, my lord. Then I'm requesting your lordship to.
We don't know whether you can say so. Because then this decree becomes in a sort of a infructuous. See, there is a money decree against you.
Yes.
It's need to be given effect to or set aside.
Please.
For you to take whatever is the benefit in that suit.
Please.
So, can we say so? In any case, the decretal amount must be deposited in that suit. Because some benefit has inured to the respondent.
Absolutely.
Have the fruits of that decree.
Absolutely, I'll bound by that. I'll bound by that. But at the same time, my right to take possession cannot be. My right to take possession and key, my lord, cannot be.
That in any case, you are within your rights to take it. Possession, obviously, you have not still taken the key.
No, still with the respondent, my lord. That's my humble endeavor.
Oh, still with the respondent?
Yes, my lord.
Even after the suit was decreed?
Yes, my lord, he has not handed over. That's only my cry.
Now, what does the court say here? Does the court say that hand over the key?
No. In the decree, no such decree, my lord. Kindly appreciate me.
No, so your grievance is only that key should be given to you, handed over to you?
Yes, key and possession as well as the arrears of due. From the day when he is.
Arrears is their subject matter.
Yes, my lord.
Should ask him. Just call the counsel for the respondent. Let's see if he has any view. Just call him. We'll take it after lunch,
No, the day after tomorrow. So
on day after tomorrow.
22nd, sorry.
Just say day after tomorrow. No. No, say tomorrow or we'll have it next week.
Next week, ma'am. In the meanwhile, I'll have to speak to my client so that,
No, ask the counsel for the respondent also to be here.
please. And 22nd, ma'am,
Just give it, ma'am, whatever is convenient.
please, 22nd.
Just one. Give any date convenient to us.
Please,
26,
Huh?
11.
27.
Out, please.
Next.
Till number 28.
Please.
For the appellants.
You are ready, both of you?
Yes, please.
We'll just pass over. Next.
29 adjourn. 30. Seal number 30. Amendment. Seal number 30.
We are ready. We are ready.
Ready.
We are ready. I will.
13, huh?
Please.
Okay. Pass over.
31. Shilpa Shah.
On last week of hearing, I made my submissions and the honorable court had directed counsel for arbitrator, like the government advocate, to procure the record from arbitrator's office.
My lords, I've received a update this morning. The records have been located and secured. They'll be sent to court later today or by the end of this week, my lord. Matter can be had on any day next week. And there was also a direction to my learned friend to
Yes,
file
that I'm
English translation.
very well aware what like the direction was to me and I followed, complied with.
What is
I
that?
produced the translation, English translation. I'm grateful to my learned friend to point it out. I have already.
Just say
produced
that.
the English.
But if I make a submission, you know, in this matter, I am being informed that the appellant authority, they have actually complied with the award and then they passed an order.
Oh, that I'm not.
That
I'll
They have
just find it.
complied with the.
I mean,
They
I'm
have,
not
they have
aware.
passed an order reporting compliance. So I don't know whether they have released or not.
And why don't you take instructions?
Yes, yes, Milord, 2 weeks, Milord, then, Milord.
Why 2 weeks?
Milord.
Who is briefing you here in this?
No, Milord, I'm appearing in this matter, Milord.
I know, briefing,
Next
there
week.
must be some officer briefing you.
Milord, project director, Milord.
Yes, pass over, we'll get it, get your
Milord,
instructions.
I won't get, Milord, I mean, because I know project director is traveling today, so I won't, Milord, just at least next week, Milord.
Have it next week.
20th.
At the request of counsel for the appellant to take instructions, re-notify.
20th.
Next week.
Milord, instruction with regard to this, that also may be.
Yeah, just say that
directed.
learner counsel for the respondent states as per his instructions, respondent number 1.
Yes.
States that as per his instructions, comma, the appellant authority has complied with the,
Passed an order of, to comply, my lord. Yes.
has passed an order to comply with the award as rendered by the learned arbitrator.
Yes.
I will,
Now, counsel for the appellant seeks time to take instructions in that regard.
please.
28th 11.
20.
Some pass. it on.
20. First door matter, seal number 8. Seal number 8, Shri Prakash Angadi.
Right, perhaps, I appear for the appellant. Notice.
Yes.
In respect of R5 may be dispensed, my lords. And the deputy commissioner, Mr. Bhatt will be taking notice, my lords.
Huh?
R5 may be dispensed, my lords.
It shows the file, ma'am.
Memo as. Process in respect of R4, my lords. The government may maybe take a notice in this. Arbiter and deputy commissioner,
Respondent number 4.
please. I'll serve a copy on you.
Pass over the matter.
Process in respect of R4 and R5 minutes. R5 may be dispensed minutes, R4 notice may be.
You appear for whom, Mr. Bhatt?
R4 minutes,
1, 2, 3 have been served.
serial number 8.
R4 minutes.
Why not? R5 should be here.
No, the R5, what happens is, he passes the,
He is the authority under the NHAI.
yes, my lord, what happens is because land is the state subject. He's my officer, but acts in consultation with the NHAI. I can appear for him, my lords, but normally the competent officer is not represented. He's an officer who's.
No, you should not, Mr. Bhatt. I think the arbitrator has enhanced the compensation.
Yes, my lord.
What was awarded by the acquisition, land acquisition officer.
My lords.
So you only confine yourself to the arbitrator.
My lords.
Notice may be ordered right now.
But what role LAC has now? See, the grievance is against the arbitrator.
And even the arbitrator is only in a role assisting your lordships.
Even he has no role.
The land losers are the contesting parties.
And you are the appellant. If you have to comply, the compliance has to be by the NHAI. No, the NHAI.
Please.
Just say that notice to 4 and 5 is dispensed with.
Very well.
That's 4, I take notice.
4, you then give
Please,
to
madam.
him.
I'll give.
Very well. R5 land acquisition officer. Let issue notice to R5.
Very well.
Issue notice to R5 returnable on. We don't know, suppose the matter goes back.
My appearance for R4.
R4 for.
9/1/25. Twenty-six. Serial number 26.
Happy for respondent.
Yes.
Appellant. In this matter, contract was awarded by appellant to the first respondent for execution of certain works. It was just 30-kilometer stretch. It was just a 30-kilometer stretch of national highway, which was contract of which was awarded to respondent number 1. Respondent number 1.
It is not that compensation issue.
No, it is not compensation. It is a contractual.
It's a contract.
Arbitration, yes. It was awarded on 1st November 2001. And extension was granted on 4 occasions and extended till 31st December 2006. Contractor, in fact, continued working even subsequent to completion of extension period because they knew that they were at fault and they could not complete just 13 kilometers in more than 5 years. And reason behind that was that 100 meter of land was in dispute and we could not hand it over to them. But question was whether they could complete the remaining portion of the contract stretch. Answer is no. So ultimately, the respondent number 1 decided to leave the contract, and subsequently NHA also terminated. Then they approached the arbitrator because based on the clause in the contract because arbitrator was the forum for dispute resolution, and arbitrator passed awarding. So there were total of 16 claims. Out of 16 claims, the arbitrator disallowed the claim number 3, 6, 12, 13, 14, and 16.
Which claims arbitrator disallowed? 3, 6.
3, 6, 12, 13, 14, and 16.
Disallowed. No challenge to
Disallowed.
this. No challenge.
No challenge to this. And therefore, appellant challenged the arbitral award in respect of remaining claims which were allowed.
Which are those claims? How many claims?
1, 2, 4, 5, 7, 8, 9, 10, 11, and 15.
And
15. So out of 16, 6 claims were disallowed and 10 claims were allowed. So appellant herein preferred commercial appeal before the district court, and in AS5, commercial AS5 of 2015 under section 34 subsection 2 of Arbitration Conciliation Act. Details of claim are like how much was the claim and how much that we have given it, page 11 of our appeal.
which page you said?
Page 11 of our appeal. Paragraph 9. So and AS5 of 2015 was dismissed, confirming dismissed, confirming arbitral award. And that is why we are here challenging the judgment passed by the commercial court. So we also had filed, appellant had also filed a counterclaim because this was a proposed as toll road. So there was a loss of toll and price escalation and various grounds because they took quite longer than agreed upon in the contract. So we also filed a counterclaim, but our counterclaim was rejected. Counterclaim was filed for rupees 42 crore 79 lakhs 56,959, which was not considered by the tribunal in proper perspective. Now, I mean, I request your lordship to just look at their conclusion is completely contrary to the findings by the arbitral tribunal itself. So I request to look at page 20 of the contract, which is, 20 of the arbitral award, which is, I will just give the page number. It is running page 116.
The complete record is there of the tribunal?
I'm not sure.
Trial court records have come.
Tribunal's record.
Ma'am, they have.
Tribunal's record is also.
No, either way, if the complete record is here, what was there before the arbitral tribunal, that would become relevant. If anything, no, we just want to ask whether you have filed the complete record.
That, they might
We
have
don't
called
want,
from trial court and whether.
No, tell us one thing, the arbitral record was requisitioned by the trial court?
I
Lord, I been told that they were,
Was it there before the trial
I'll
court?
just tell you lots what our difficulty is. The respondent company is undergoing liquidation in the NCLT Hyderabad. So I'm only representing the liquidator of that company. So
Oh.
therefore my hands are to that extent. I'm only going.
So
by-
you mean, okay. No, you
Learned
must be
friend
telling,
would,
see, we don't want, we want that record should be here because ultimately we need to look at the record. Ma'am, just check up that. She's asking something.
Normally the claimant should assist your lordship, but this difficulty is something that. In fact, the only reason that liquidation order has not been passed is these proceedings, but that's the. Obviously, depending on if we succeed, then the liquidation estate, there is some change. Can I only point out one thing? The grounds are only really on reappreciation of merit. That's really the sum and substance of it. Be that.
Hmm. Hmm. We don't have the reference. Has it come? Is it in the code? Although there is an order to call for the record, let's see. We'll check up, maybe it's in the branch.
Please.
Yes. Check up after lunch.
Page 100, running page 116. So this is page 20 of internal page 20 of the arbitral award. So prior to that, there it starts arbitral tribunal's finding and analysis and reasons. Paragraph 14.4. Your lordship got it? Page 116. Running page 116, paragraph 14.4.
This page is understood. Give us the file. Give us the physical file. Yes.
14.4. From the facts and evidence produced before us, we find that the claimant has treated omission of a part of the work by the respondent as repudiation. The document submitted to AT does not reveal the intention of the respondent not to perform the contract. The claimant has not been able to demonstrate this aspect. Merely omission of 100 meters of road cannot be taken as the respondent's intention of repudiation of the contract. The claimant had several other remedies available to him as per the contract and acts for redressal in regard to compensation either for omission of part of work or delay and stopping of the work is not correct. So finding is very clear by the arbitral tribunal that intention of the respondent was omission of was not there, and they have failed to demonstrate that merely omission of 100 meters of road cannot be taken, that respondent in repetition of the contract. The claimant had several other remedies available to him as per the contract and acts for redressal in regard to compensation either for omission of part of work or delay and stopping of work is not correct. In view of this observation, it is of the opinion that the claimant's action in discharging the contract on the ground that the respondent has repudiated the contract is not correct. This is the clear finding by the Honorable Arbitral Tribunal. Then I request your Lordship, paragraph 14.5, just next page, 117. 14.5. In view of the AT findings and reasons provided in paras above, AT declared that the discharge notice issued by the claimant with the letter dated 18/3/2008 and the termination by the respondent with their notification dated 30th/4/2008 are incorrect and not in accordance with the contract condition and the provisions of the relevant acts. So, because they claimant, that is a respondent number 1, first issued letter dated 18th March 2008, declaring that is a discharge notice. And NHI, the appellant, then issued termination notice, the 30th April 2008. So this arbitral tribunal say are incorrect and not both. They say their and ours are incorrect and not in accordance with the contract conditions and the provisions of the relevant act. So after first paragraph, 14.4, clearly said they were wrong. 14.5, both were wrong. And then ultimately, passing the word, our counterclaim is rejected and their this thing is claim is awarded. I request your lordship to now look at page 123. Page 123, para 15.5. The following are the finding of AT based on the documents and arguments made before. What has it done? Like now each claim, they are saying what claimant had to say, what respondent had to say, and then arbitral tribunal's finding. So the following are the finding of AT based on documents and arguments made before AT. It is true that work got delayed beyond the scheduled completion period on account of various reasons. Competent authority granted EOT without imposing any LD. As per GCC subclause 44.2, the claimant is eligible both extension of time and additional cost. B, AT is in agreement and all extension were given with condition that there won't be any additional cost to the appellant. B, AT is in agreement with the respondent argument that there are delays on the part of the claimant. AT observed from the documents made available that the claimant was unable to complete the stretches which were encumbrance free. Only 100 meters, it keeps coming in entire award that it was just question of 100 meters. There was a 13-kilometer stretch.
But the rest was complete?
No, that is the rest was not complete.
Even rest was not complete?
Yes, that is what here, arbitral tribunal is saying. AT is in agreement with the respondent argument that there are delays on the part of the claimant. AT observed, so agreement that yes, they delayed. That is respondent number 1 delayed. AT observed from the documents made available that the claimant was unable to complete the stretches which were encumbrance free. So 12 kilometer and 900 meter, that also they could not complete. So there was no reason for them to not carry out work on that stretch, which was encumbrance free. Just see next to B, C. AT also observed that as per the engineer's letters, the claimant has not mobilized some of the key personnel required for the work. So these are all findings by the AT that there was a delay on the part of claimant. Claimant didn't complete, though there was encumbrance road, possession was given to them apart from that 100 meter, that also they have not completed. Then that they have not mobilized some of the key personnel required for the work. D, next page, page 124. The claimant has not produced proper documentary evidence in support of the claim as argued by the respondent. The claimant has claimed the amount based on the Hudson formula. Honorable courts in many judgment allowed adopting the Hudson formula. As such, it allowed adoption of Hudson formula in the absence of documentary evidence in support of the claim. And then ultimately, it, everywhere, your lordship would find that again, page 129. 129. Page 129, paragraph 16.4. Again, 80 finding, analysis and reasons. I'm not reading what we stated or what was our submission. I'm just showing everywhere what was arbitral tribunal's finding. Page 129, paragraph 16.4. 80 finding, analysis and reasons. The claimant's claim is based on assumption that had the work been completed within the scheduled period, he could have utilized these resources.
It's a unanimous award?
Yes.
No minority?
No minority.
Okay.
So in spite of saying all this, they are rejecting our counterclaim and they are awarding what that your lordship would find at page 186. Interests are also, awarded cumulative, contrary to the law, but I'm just to put it short, page 186, award, paragraph 13.6.
Yes.
80, after considering all the documents and also findings / reasons as indicated above, disallow the counterclaim of the respondent amounting to rupees 42 crore 79 lakh 56,959 on the ground of lost revenue by way of toll collection due to delay in completion of the work by the claimant. The arbitral tribunal has gone through and examined all the written documents submitted, oral or written submission of both the parties, including documentary evidences, have heard both the parties to their full satisfaction and have applied our mind to all the evidence and material record put up to it on all the above claims and counterclaims. The arbitral tribunal has further deliberately, fully and analyzed all the claims rationally, logically, and consistent with contractual clauses and have thoughtfully considered the various aspects placed before the 80 and now having duly applied our mind in the matter in the light of facts and circumstances of the case, do hereby make and publish the unanimous award in respect of the claims and counterclaims referred to it by the claimant and respondent listed above claim-wise. And then there is an annexure, and so basically they have so in my respectful submission, all these conclusions are contrary to their own finding. And now I request your lordship to look at the judgment, impugned judgment passed under section 34. Page 73. Running page 73. Okay. 73. Paragraph 20. This is I'm reading from the judgment, impugned judgment passed under section 34(2). Paragraph 20. In fact, the impugned award is a detailed order and all the issues are discussed with reference to the documents produced before it. Even the arbitrators have mentioned that they have heard lengthy arguments and perused the written arguments submitted by both parties. They have discussed claim-wise. While discussing each claim, they have given full details and reasons why the claims of the claimant on each claim is to be awarded and why the counterclaim of the plaintiff is to be rejected. When such being the case, the said award cannot be considered as non-speaking order. Now, when we say speaking order or like a non-speaking order, it doesn't mean that it's a, I mean, how lengthy it is, or it's like 100 pages or 200 pages, or it is 5 pages. Whether the finding and like conclusion, that like now reasoning for conclusion, whether it's matching. That is the whole idea. It's not that like he's saying because they, and everything they say, they have stated, they have stated, they have stated. Arbitral tribunal have stated that they have perused the written arguments, they have perused the documents, they have discussed, they have done, and they have said that why they are. So, I mean, I can take this honorable court claim wise, but I'm just putting, just showing these few things.
Nandakumar, what do you say on that?
But
What is the conclusion under 34?
34 conclusion is quite clear. It is that the award is, does not require any interference. Please be kind enough to look at.
Tell us one thing.
Please.
The awards are being challenged. Surely they would be on facts, would be argued, in law would be argued. Is it not an obligation under 34, and that's the first judicial remedy effectively? Is not obligation on the part of the 34 court to consider all the submissions on whatever counterclaims rejected, certain claims rejected, certain claims awarded.
Please.
Only on an interpretation of 34, the 34 can be decided.
But can I just make this submission? Perhaps this is a dilemma that every 34 court would face.
No, there is no dilemma.
I bow down, Murad. I don't think there's a dilemma, but I'm just saying that
34, these are the facts, this is what being argued. Very well, in this argument, this is the conclusion drawn by the arbitrator.
Right.
Whether this conclusion of the arbitrator in this fact can be interfered, this is the scope.
may I just look at it slightly differently? Please permit me to just present an alternate view and if your lordship may. Under 34, there are certain grounds and there are only those grounds that are available for interference. Of course, we are not on constitution and notice and all of that, that goes away. So essentially it comes down to either material not being considered or extraneous factor, that is without any material, a conclusion basis. These appear to be the only two places where the claimant can fit in. This is considered by the Malad trial court. Please see, in the commercial court. Please look at this. Please be kind enough to come to running page 70, internal page 12.
Yes.
About 8 lines from the top. He has not, about 6 lines from the top. He has not made any grounds to the effect that the impugned award is capricious, arbitrary, or perverse or against public policy. He has not made any ground as stipulated under 34.
But what are the grounds he has urged?
Please just see that. During the course of the argument, only point raised by the advocate for the plaintiff is about whether the claimant is entitled to compensation even if the contract is terminated. Arbitrators have found that the termination of the contract is illegal and the final extension was granted till so-and-so without imposing liquidated damages. And thereafter, no fresh date was communicated to the claimant for completion of the work. As found above, arbitrators were not bound to give reasons for arriving at the conclusion of the award. The arbitrators have stated that they considered the relevant available documents and applied their mind judiciously to all points raised. Appreciation of evidence placed before the arbitrators, the task of the arbitrators cannot be appreciated evidence. Now, the only point that was urged was whether compensation can be granted despite termination is the only ground they seem to have argued.
Right, the grounds have been raised. Factual grounds raised that in the fact, now what is being sought to be argued is this.
Yes.
Grounds raised, these are the conclusion arrived at, but still he has given it, reiterating that in this fact scenario, okay, the termination could not have been, the termination should have been, who has terminated? They have terminated.
What happened was, initially, I sought to say that I'm discharged because you are not giving me the free access to the road, to the area. Without that, I cannot do any work. They terminate the contract. Both are question. The arbitral tribunal finds that I could also not have discharged. That is the finding that my learned friend reads. And importantly, finds that the termination is invalid. That is the point I'm submitting.
Right, on a fact situation,
Correct.
One, if says the termination is invalid, they have raised certain factual basis for saying that this conclusion is not correct.
Correct.
You should have dealt with and may reiterate what the
I bow down, but please be kind enough to see what is recorded by the learned 34 court. He records that the only point raised is whether they're entitled to compensation upon termination. These points, whether they were, once the tribunal, once the 34 court records this, we have to go by what was said. Then please see the next page also.
Before my, just sorry to interrupt, just one line here. Sorry. Here, as found, I mean, the same paragraph which senior counsel read, as found above, the arbitrators were not bound to give reason for arriving at this conclusion.
Pardon, where?
In the same paragraph,
Yes.
liquidated.
I read that out. I did read it. It's- I
As
did
found
read that.
above, the it's
Mhm.
paragraph 16. It's last, but like about 7th line from bottom. As found above, your lordship found it. As found above, the arbitrators were not bound to give reason for arriving at this conclusion. So district court is wrong here. Court says.
That clearly appears to be a
provi-
typographical error and because it's not consistent with what he says elsewhere. Please see the next paragraph. Please see the very next paragraph, paragraph 17, 18 and so on. I'll just read. What there is. I cannot now improve the case and do anything with it. It's what it is. I'll just point out. Please see 17. Says arbitrators have relied on the documents and referred to in the award on each claim in detail. When such being the case, there are no mistakes. Then,
Kumar,
yes.
this is the basis. Then no award, every award would be upheld.
I don't agree, Manoj. I'll just tell you, lordships, why, Manoj. I beg to differ. I'll tell you, lordships, why. If I can point out from a reading of the award that those conclusions were, my lord, opposed to material evidence that I can show, then that 34
You're right, we are with you.
But my submission is that from a reading of, my lord, ultimately, once an order records that this is what was argued before me, the only person who can set that aside or rectify it is that court. Now, if it is so that the only point that was raised is about compensation, then, my lord, none of these contentions can be considered. My lord, I must
We will see that what is the 34 petition which they have filed.
Please let us know.
See, what we are saying is this can be the final conclusion of the learned court.
Of course it.
Based on a factual finding.
I completely bother.
We are on that.
But I must also bring to your lordship's notice something else that may be against me. Please see paragraph 18. Please see, my lord. I must tell your lordship's, I should bring it to your lordship's attention. It should not be that. This has been dealt with in a brisk manner. I don't say otherwise. Please look at paragraph 18. Though the learned advocate for the plaintiff has argued at length, all the said arguments are about the merits of the case. He's not pointed out that the impugned award is liable to be set aside in any other grounds mentioned. He's not pointed out any patent illegality. Then on a para 19, on a perusal, the learned arbitrators who are reputed engineers have mentioned the facts of the case, relevant clauses, details of the proceedings, contentions, etc. Thereafter, they've discussed each claim by giving details of the brief description of the claims, submissions, etc. Counterclaim, and thereafter their findings, analysis and reasons about the said contentions, claims, and thereafter they pass their award in respect of each claim. They have also discussed about the counterclaim of the plaintiff, and after giving proper reasons, they rejected the said counterclaim. Plaintiff has not specifically shown any of the said findings is contrary to public policy, etc. So this is what he concludes. But your lordships are right. It is not juxtaposed with the facts. It is apparent. The order, it's what it says. One other thing.
Tell us one thing, ma'am. How would you come out of this submission which Mr. Nandakumar has raised at para 16? Any grounds to the effect that the impugned award is capricious, arbitrary and perverse? He has not made out any grounds.
And can I point out one more thing, my lord? Please be kind enough to turn to paragraph 5 at running page 64, internal page 6. Please see what grounds are raised by them. That is
The
summarized.
only point raised by the advocate for the plaintiff is about whether the claimant is entitled the contract is terminated.
My lord, as your lordship rightly expressed, we have to look at the petition.
We will
34
see.
petition, whether we have not raised all the grounds which we are raising here, it's like continuation of 34.
Very well,
petition.
we'll call for that, but you don't have the record yourself. Ma'am, we'll just check up, whether the record has come.
But can I just bring your lordship's attention to one other point? Paragraph 5, my lord, running page 64, internal page 6. The learned judges try to summarize the facts in their petition. Please, for a minute, please look at it to see whether these would fall within 30. That's why I'm pointing. If straight away it doesn't, my lord, today we have a handicap. The learned friend was not appearing in the 34 court. We were not even in existence, in the sense the liquidator had nothing to do with it. Therefore, please look at this. I'll just read it out. Finding that the termination is improper or erroneous, award in respect of the claim needs to be set aside. Arbitral tribunal has wrongly calculated cost from the date of original completion date, though final EOT was issued up to so. This is total reappreciation. Point Roman 2, para 5.2 is nothing but reappreciation that they seek. Please see 3. I'm reading from the summarization of the learned judge of their petition. Please see Roman 3, my lord. Contractor utterly failed to execute contract in spite of extending additional financial assistance by way of loans, so and so, so and so. Again, reappreciation. 4, my lord. Tribunal wrongly calculated increase of cost. reappreciation, my lord. 5, price adjustment of 54% is on the higher side, reappreciation, my lord. 6, tribunal upheld the rates determined by the engineer in all 5 cases, reappreciation. 7, my lord, soil investigation, again reappreciation. This is why I'm pointing. The grounds, even if your lordships, my lord, were to reconsider, of course, I did point out on something else, which is that portion, paragraph 18 is a little crisp. It should have been a little more elaborate. My lord, I cannot say otherwise. But even if these are the grounds urged and that cannot be considered, my lord, is my respectful submission in that. That is my.
We call for the, let's see
Please.
the record. Let me just check up the record has come.
You know, in my small submission, you know, in paragraph 16, the 34 court has specifically said that arbitrator was not required to give reasons.
From the record come.
And
Huh? They have come. The record has come. See, the record has come. They have to just trace it out.
in which case, may I make one request? The lordships are kind enough to consider keeping it on 15th perhaps. The reason is then the counsel on record can also just study it and see if there is something.
No.
But suppose written submissions have been filed, then I can't argue against that. That's the only, today I'm totally handicapped. I'm only placing from the award and the order.
Where the written submissions were.
I'm just saying in the 34 court, for example, suppose written submissions are filed by the parties indicating what was argued, then my lord, perhaps that will point out, because that finding in paragraph 16 may then have to be seen in that perspective. That's the only thing.
Just say this, in terms of order dated so and so, when that 22 order, no? The trial court record were requisitioned. It was requisitioned. So we have been informed that the record has come to this court. Appropriate shall be that the record shall be sent to the court on the next date of.
Please.
Now, let's see. Very well. See. We were just only saying possibly you can file your brief note of submissions.
We'll do.
Both of you.
We'll do it.
Just file it.
May I make one request in that case? Please give us a couple more days after that, because otherwise.
I will give you 2 weeks at least. Just have it in December, ma'am, this matter.
But I appear for the respondent number 5. May I also be permitted to file my written submission?
Respondent number
5.
Lord, we have.
Respondent number 5.
Was impleted.
Lord, he's the suspended board of directors of the respondent company.
I was totally involved in the entire case before the arbitral tribunal.
He may be able to throw more light on it than us then.
Pardon?
I'm saying he may be able to throw more light on it than he was involved in the arbitration.
But I don't know whether he will, I mean, get
Yes,
any
yes,
benefit
that-
out of
that-
all of this.
Want to file it.
Much obliged.
Lord, we have already filed.
I don't know. What in view of the fact that the liquidator is in place, what would be your role? And this implement is after the liquidator was appointed?
Yes, it is in these proceedings. It is in
These proceedings. When was the liquidator appointed?
I'll just tell you lordships of liquidation.
Okay.
Lord, we
Because
have,
it went through CIRP, failed, and there was the liquidation.
we have filed detailed, Lord, synopsis running into like.
You have filed it?
Yes.
So Nandakumar, you will file.
We'll
it.
file it.
Whatever you want to do, we say nothing on that.
Much obliged.
Okay, just give me.
Lord, 2023 August is liquidation. Liquidator was appointed.
This bundle. Sir.
These are the
Bundle.
records.
Sir.
Lord, please permit the counsel on record to just look at it.
Give it in December. In Western Regions. The second week of December. How many matters are there?
23rd November is a working. November is a
We
working.
will have it in December.
I'm-
We have it on 5th of December.
5th, I'm sorry.
But I.
I
Thank
only
you.
advise my learned friend to wear a mask before opening those bundles.
I've been told, these records, they occupy a lot of space. That's the reason, in fact, we were verifying that's, in fact, it's just a request to everyone.
Digitization.
I was also thinking that call for the soft copy from the court. And we have the soft copy
Absolutely.
here. That's the way best.
But there is one practical difficulty. I'm sorry, I'm holding up some other lawyers, but I'll just take a minute and express. There are 2-3 things, Manoj, perhaps time for the court also to consider. What is happening is that in many cases, a soft copy filing is not done at all. In fact, in most cases, even in the commercial court, there is really no reason that should not happen because most counsel today have a lot the access to scanning and so on and so forth. That's certainly something that should be done. In the NCLT, we have a very peculiar problem, I'm told. Every single petition, application, memo, anything has to be e-filed. But nobody even looks at the e-filing. They still insist on a physical filing and it's only the physical filing that
It's the other way. There. We want, at least surely in commercial matters.
Commercial matters, my lord, and tax matters straight away can be.
There is a this thing also, e-Seva Kendra also. One can go there, just give it, he will upload it. And we get it. Otherwise, the scanning here,
Yes,
let's see, we should
please
work it out.
So grateful.
Yeah. Next matter, ma'am.
Serial number 28.
In this case, don't know, my lords, if the records have come, records were called for by order of 17/10/2022.
How long it would take?
About possibly an hour.
From you, from your side?
Yes.
We have it some other day.
Please.
That we will have it. Just.
There's one difficulty here, my lord. They have, during the pendency.
Can have at 2:30, but that will only go in January.
No, my lord, we can have it on a day which my lord suggests. The only difficulty is they've moved an execution petition and they're pressing that. It's on
What
16th.
is the date of that?
16th. That is the day after.
They have not deposited the money. In 2022, when the matter came up for stay, they did not want to deposit, therefore they did not press for the stay application to be heard.
But is it, the year is 2021? But there is no stay of the impugnable.
Execution was filed in
The day after that, the day which we had.
Please,
on 16th,
please, my
well,
lord.
Please,
Please.
The execution thereafter.
And that will be,
them deposit, my lords, the sum.
Why don't you deposit also?
my lord, we'll argue this matter out.
How much?
Lords,
How much?
the
My lord,
award
the
is,
the situation is
the award?
this. My lord, may I
much
make the
How
submission?
much is the amount?
This is, the award has been set aside on the petition filed by him as well.
Set aside.
The award has been set aside. The award was challenged by both parties. His suit came to be allowed and the award was set aside.
And what happened to your challenge?
In view of his suit being allowed, my suit challenging only a portion of the award
That also goes.
So therefore, there's no award.
There is no award. Technically, it becomes infructuous.
Absolutely. So what is he executing?
Is it a case?
lords, the award had granted me 49 lakhs with interest. The 34 court made it 98 lakhs with interest because there was some deduction. The 34 court says that deduction has no basis in law.
Now, what happened to that 34 of yours?
Lords, my 34 was allowed
Was allowed and enhanced.
and enhanced.
What happened? Any challenge by them?
Yes, yes, the connected appeal is before my lord.
That is
Yes.
challenged.
In the light of Samudra, the arbitrator could not have sat in appeal and decided the matter.
Question is now before the Honorable Supreme Court.
That's right.
Still hold the good.
That's
What is
right.
the law which holds the field today.
But there are both judgments. Fact. May my lords pass on that one order for your lordship's kind consider.
We'll give you the latest order of the Supreme Court.
My lord may have it on the day next after this is heard.
Challenge dismissed or
It's a
award
severable
set
award.
aside. Award set aside.
Lords, it's a severable award here.
We'll see it.
Please, courts.
Now, very well, we'll have it on 16th.
Please. Great.
No, but insofar as his prayer is concerned, what do you say on execution?
Lords, he has to deposit the money.
No, there is no award on.
Yes, he has not done it.
Very well. At least you should report some amount, show your bona fides.
My lord, we've had this matter pending from 21. The execution was filed in 23. And we moved this
It's all
matter.
right, that inured to your benefit. They did not pursue their execution before that.
That's right. My lord, what is there is no award existing to be executed in the light of Samudra.
No, but he doesn't say so. He says it has been enhanced.
No, it has been set aside.
Are you sure it has been enhanced? See, what he's been saying is the award doesn't exist in law.
No, it has been set aside and the court has sat as though he's the adjudicating authority and considered everything and passed a judgment.
Lord, the order says the respondent, that is
We
the
will look into it. I think we'll have it, but don't press that. You take a date beyond this date.
Lord, my respectful submission is he should deposit. He cannot.
Tell us one thing on this.
Please.
Award set aside, 34 court take upon itself,
Please.
reconsider all the claims and gives a fresh award.
No. The short facts, my lord, sir, I had given a security deposit. The tribunal said some portion has to be set off. I had given 98 lakhs. Tribunal says 48 lakhs he can keep. 50 lakhs is to be refunded to me. The 34 court says no, the entire amount should be refunded to me.
That would be an issue need to be looked into.
Lord, now at least he must deposit.
Do one thing, take
Please.
a date beyond 16 December.
Lord, let him at least deposit the sum that was awarded by the arbitrator with interest. At least that, my lord, he must show his bona
So we have
fides.
some difficulty there, my lord. Due respect, my lord, if this had
No.
happened earlier, we would have
See,
moved the matter.
He's now going back to the arbitrator award. He says, to the extent what arbitrator has.
Assuming his challenge is now
Good,
holds good. He's coming back to
And-
my challenge.
You say how much you will.
My lord, there is a
deposit.
patent illegality which we'd like to
That
highlight.
we will see. We are,
Oh.
that we will see.
My lord, may I make this request? At the, I can take there's no difficulty, my lord. But since we are at I can
much
argue
will
this matter
decide?
even next week or any date, my lord may fix.
See, we have to see our board also, please.
I quite understand.
Now, please, how much you will deposit? So a bona fides. We will see. It will be, the amount is lying in this code. It's not going out.
I'll have to take instructions, my lord. I can't quote a figure off.
We will take instructions.
Yes.
When do you want?
No, Monday.
We'll have it next week.
I mean, if next week, if it reaches, my lord, we'll argue it if the court has the time. Yeah, we'll take a chance. My lord may list it for hearing.
But this 1 hour is.
No,
you have
I'll take 30 minutes.
You have to abridge your submissions.
I'll take 30 minutes. My lord permits me.
See that. Okay, then we'll give you a date. When is the day? 16/11, huh?
16/11,
16 is when?
day after, Saturday.
You see, before day after is not possible. It was our diary.
That is just
29/11.
Until then, my lord, my friend may not
My lord, if
precipitate
he's
matters
not-
over there.
Let him, my lord, say 230, then make a submission as to how much he'll deposit. It's more than 2 crore, even going by the award.
We'll see, 29/11.
Great.
We say nothing on that. What we are saying is,
Hold
so, but you have to take instructions also. We'll have it on 29/11, before 16/11, it's not possible. Or both of you can take a date, let him take instructions, how much money he's depositing in.
Please.
Will it not be appropriate? So 16, both of you take a date before the executing court, beyond a date of 29/11. He's getting instruction by that
Please, my
time.
lords, I will take a date on.
I'm grateful, my lord.
That's how it should be.
Please, my lords.
Okay?
May I also say this, my lords?
So
Attempts were
we
made.
say nothing on this with an
Please.
understanding, both of you will taking a date.
But he should come back on the next date with instructions on how much he will deposit.
He says so.
Please.
He says
Grateful, my lords. I will do that.
2911, okay?
Great.
For to enable the counsel for the appellant to take instructions.
My lord, certainly.
That's what we have said. Thank you.
Great.
Which is the man, ma'am? Yeah. And that Joel was there, no? Yes, Mr. Kumar.
So sorry, I was held up with other
Yes,
matter.
what is the issue?
The issue, my lords, the arbitrator has awarded.
Come back after lunch.
Publish.
Okay.
Publish.
It's 2,000.
My God.
ಈಗ ಮಾತಾಡಿ ಸರ್.
Hello.
ಇಲ್ಲ ಬರ್ಲಿಲ್ಲ.
ಇಲ್ಲಿ.
ಕರೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ.
ಹಾ. ಈಗ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಮೋಸ್ಟ್ಲಿ ನಾನೇ ಇಲ್ಲ ಇದೆಯಲ್ಲ ಕ್ಲೋಸ್ ಆಗೋಗಿತ್ತು. ಕ್ಲೋಸ್ ಆದ್ರೆ ಕ್ಯಾಮ್ರಾ ಬರಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಅವ್ರದ್ದಷ್ಟೇ.
Exactly.
Yes. Mr. Kumar.
Till number 30.
As I am permitted to file the trial court records, which have not been called for in the section 34 petition proceedings.
Lord, he's handed over this today afternoon, my lord. This entire records is handed over today.
We will not look at it.
Okay. Because I have not gone through that.
We have not. Let's see, he will take us. If any paper is there, we will see it.
Yes. Now, Manners, the appeal is filed challenging the order passed by the commercial court without addressing the grounds raised in the section 34 petition. Despite this honorable court coordinate bench directed all the trial courts to address the grounds on which the petition was filed. In the Union of India versus Warsaw Engineers, 2-3 years back, it was circulated amongst all the judges, district courts who were dealing with section 34 petition.
Where is the judgment?
That's why I have extracted the operative portion in the.
We want complete judgment. What is the citation? We'll take it out.
Yes, that's yeah. Form AP 25 of 2021.
Just take down that citation. Get a print.
25 of 21, decided on 17/4/21.
Citation.
COM AP, that's COM AP 2021. Our. Let's say quarter one. 17/4/2021 decided, sir. Number website.
This quarter.
No, this quarter. 2021. 17/4/21. So sorry, Manoj, sir. It's judgment. I'm sorry, Manoj, it's not contained in my volume. That's the thing. Now, I'll just proceed a little further matters. I'll place it on record. The contention was raised before the tribunal as well as before the trial court matters. The award is basically contrary to provisions of law, means agreement. The three conditions which the learned arbitrator did not address himself at all. One is we have levied a compensation for belated completion of the work. Second one is that he has asked for certain amounts said to have been executed at work. Now, in that context, my lords, ours is a specification is being given, and unless until that is modified by way of an order or a decision by the authority, or we instructing him in writing saying that A is a specified work, this requires to be modified in so and so way or anything. If he himself voluntaries, for example, you have said you make only the particular centimeter thickness of the compound or this plastering. If he voluntarily does anything else, for which I am not entitled, because it's a public money, we cannot, the way he works, he cannot be, he must adhere to the specifications specified in the tender, not beyond that. Here, the learned arbitrator has made two jurisdictional error matters. Firstly, in awarding claims 1 to 10 in subclaim number 1, what he contends, in one paragraph he says, yes, there is condition number 23, which deals with every communication should be in writing. Accordingly, he says that yes, unless and until there is a communication in writing, contractor could not have executed this work. He disallows. But in other claims, similar stand, but he allows. I will take to your lordship to the award passed first, so that it can make a complete comprehensive approach towards the manner in which the arbitrator has looked into. Second thing is, my lords, with regard to delay, what is in content, he himself he does not look into any of the communications or exhibits placed before him by the both parties. He himself calculates, saying that it is actually building a fence. There was a 3-meter compound in Yelahanka Air Force Station. After this Pathankot, the attack minutes, they wanted to increase the height of the compound. There minutes, it was in some places 3 feet. It was increased to additionally, and also barbed wire fencing was made with L angular. That is a work which was he executed. Now in this case minutes, he himself sought for extension of time. In one occasion, it was considered and given. In another occasion, there were no reasons. We did not extend, we rejected it. But the learned arbitrator holds that I did not take any decision at all. So that's how he has come. Apart from that, the learned arbitrator does not look into the material placed on record by both parties. He says the total extent of running meter is around 950, 850, 890. So for every day he was to execute 60. So it takes so many days. He himself has calculated. Our entire work completion period was only 9 months, but it has gone beyond that. So that's what I would like to show Lordships in the presently what I have placed on record minutes. It contains every material. Now, firstly, I would like to turn to pages, volume 1 minutes. Volume 1, page number 185 is the award. That's got it. May I proceed, minutes? Page number 192 is a discussion.
See, let's confine ourselves to
Yes,
claim 1, claim 3.
yes, ma'am. And counterclaims.
That's all. Counterclaim all rejected.
Yes, ma'am, all rejected. Now, the claim 1 minutes, there are sub items.
Where is the finding of the arbitrator?
That's one. Page number 192 may be seen, minutes. Page number 192 commences the award portion. 193.
Why do you go that far? Come to an earlier page. Page number 45.
I'm sorry, I'm just referring to the volume what I have handed over now, so that it will be convenient instead of switching over to volumes.
Very well.
Yes, so sorry.
So what was the claim 1?
Claim 1, sub-claim, it is payment for provisioning of rainwater drain at security tower number 1 below compound wall minutes. Now kindly turn to page number 193. That award says, I am of the opinion that a claimant should not have executed the work without an order in writing. Also, claimant could not produce any other documents or proof that the said work was executed by him. So I came to conclusion that the claim is not due to claimant and rejects. Same contention we have raised in all subclaims of claim number 1. Now turn to next claim, subclaim, where very contention has been rejected by the arbitrator for the next subclaim. That is at page number 193 minutes. Same page, bottom minutes. Again, the contention he records. Contention of Union of India is based on condition number 23 of IIFW 2249, and also says that only 450 mm wide drain has been constructed, claiming verification at site. Now, firstly, we said we have not ordered him to increase the width. And now, in the previous claim, the very arbitrator said that unless it was in writing, it should not have been. And now he came down, he says,
Very well, we'll do one thing. We can allow this claim also on the same analogy.
No, it can't be.
Why not?
Can't
See,
be.
what you are.
I understand that vice versa can be thought of, but what I'm trying to say, my lads, condition number 23 makes it very clear.
That's right. We are with you on that.
Yes.
So once he has allowed that part,
yes,
we'll allow this.
No, this can't be done. That's what I'm saying. It will be contrary to the terms of the agreement.
How much he has awarded, Mr. Kumar?
But if you look at it, 18% interest plus together, it comes.
So you are more agreed by the interest. That's right.
That's
On a claim, no issue.
claim to some extent.
1,85,000 he has awarded against how much claim? 13 lakhs.
That to that extent, one time.
Now come to which is the other one which he has allowed.
Other one is
Reimbursement of the amount recovered, 6 lakhs,
that
42,370. These are the only two claims allowed.
That's it.
You have any issue on that?
I have issue on the claim or the recovery of the amount. That compensation amount levied, which had to be allowed in our favor because reasons are there. I have explained that he has not reasoned anything. I will just show the records from the record.
You show that claim.
Yes, ma'am.
How much is the interest?
Interest, yes, order 18%.
Ma'am, you have anything to say on interest? Is the contractual interest
No,
18%?
no, Manoj, no. It's not contractual.
18% would lie, tell us.
My lord, it was-
12%.
It was not contractual interest, my lord.
It's not a contractual
It's
interest.
not-
So if it is not contractual, discretion. But
It was-
discretion should not be at 18%. Discretion should be whatever is the banking interest.
It's a 12%, yes, made.
Unless contractual, which says 18%, he is within his right.
It's not the case. Now I request your lordships to turn to the regarding that delay
Let's
of
compute.
page number 201 may be seen. Manoj. That's why the discussion is there as far as their claim is concerned.
Which page?
201 minutes in the first volume only. So sorry. It is pertaining to award only minutes. Your lordship is convenient with the first opinion, it should find.
201.
201. Two zero one. 202 is the discussion of the learned arbitrator.
Hmm.
201, last paragraph, I will just read it. On this, while discussion during the proceedings, it was mentioned by the claimant that CA provision does not allow for 60-meter stretch only, but it does not debar the GE to hand over more than 160-meter stretches at one point of time. By this way, the work would have been completed in time.
Now
Manoj,
let's read his contention first.
yes, Manoj, is read out.
The claimant through various letters.
Various
requested-
letters requested extension of time for the reasons not attributed to him and beyond his control. The accepting officer did not decide extension of time, which is contrary to condition number 11 of so and so. I will read further. Minutes. Respondent decided an amount of so and so towards alleged compensation for delay and compensate the work from the final bill. The said action of the respondent is arbitrary, wrongful, and uncontractual, and therefore not acceptable to the claimant. Manats, I will show the records now. Firstly, Manats, the contention the arbitrator said in the last paragraph, he says that there is no prohibition in the contract agreement allowing more than 60-meter stretch for work because it is a security technical area Air Force Manats. Every day, that is a condition which was imposed in the condition. Kindly turn to page number 369.
Read your stand now.
Yes, my stand. Union of India contended that the work was delayed due to contractual default on account of less deployment of resources by the claimant. Union of India also contended that the site was to be given in a stretch of 60 meters only due to security reason. In this connection, Schedule A, note number 11, on page number 12 is referred by Union of India and contention that the decision for grant of extension by the CW is final and binding as per the CA provisions matters. Now, first three items which I would like to stress upon your lordships. The first one is that page number 369 minutes. The contractor contended there was no prohibition in the agreement giving beyond 60 meters stretch for working. Kindly turn to page number 369. That is a part of the contract which has been signed. Volume number 2 minutes. Page number 369.
No, we'll come to that. Read his finding.
His finding minutes that before that I wanted to refer them. I will read it. Then I asked the Union of India that if one or more stretches were given to claimant for a simultaneous execution, but the answer was never affirmative. I also calculated, he is very important, man. Kindly look at it, sir. I also calculated number of days required to complete the wall length from demolition to erection of barbed wire fencing, before which the next stretch was to be handed over for execution, and found that minimum 35 to 40 days are required for the same. A total of 892 running meter wall was to be constructed with other allied works So minimum time required for completion of work is 892 divided by 60 is equal to 15. 37.5 days average of work for completion of the work is 562 days. And the work was completed by the claimant on 31st December 2012 with commencement on 4th July 2000, that is 546 days. We are disputing the very fact there is no basis. How did he calculate? The entire work is 9 months, including all other work. He does not discuss it on what is the basis he calculated. Simply he arrives at, no, without placing any material on record, saying that this is the stretch of time is required to complete the work. I don't know what is the basis for him. Neither me nor the contract claimant has placed any material record to show that this is the time required to complete one stretch. But it is arbitrator's own calculation, not provided a calculation also here matters. This is a patent illegality committed by the arbitrator. Now, further matters. More so, I have gone through the rival contention of both the parties as contained in the written submissions and also heard their oral arguments. I have also perused the provisions of conditions 11 of IAFW 2249, and I am of the opinion that to make decision of accepting officer as final and binding in respect of extension of time, first and foremost requirement is that the accepting officer has to take a decision, recent decision and convey it to the contractor through G in writing in the manner prescribed in condition number 11A of so and so. However, request of contractor extension of time up to and including 31st December 12 has not been decided by the absentee officer of the contract. It is contract records will show it matters. Thus, the most basic contractual requirement laid down in condition number 11A of IAFW 2249 to make the decision of accepting officer as final and binding beyond the jurisdiction of arbitrator has not been complied with by Union of India. Therefore, I decide that this claim is well within the jurisdiction of this arbitration. Therefore, I had come to the conclusion that the not granting of extension of time by the CW is not justified since the claimant was not having adequate site available to increase the resources to complete the work in time. I award rupees so and so on account of the amount recovered by Union of India on account of delay in completion of work as compensation. Interest component claimed by the claimant on this account has been separately detailed under claim number 13. Now I will show the document.
Tell us one thing. Yes, when he delayed, did you terminate the contract?
No, its extension is given. We have refused. Once we have given extension minutes. Other time he asked, there are no justification to grant the extension.
So what will you do if you don't want to give extension?
Just either we terminate the contract or we accept the work what he does.
Did you terminate the contract?
He did not.
Then you don't terminate the contract, neither you decide his application for extension.
Decided matters.
What?
I will show you that. That's what I said. It is a contract records. I have got records placed.
Show us that.
Kindly. Firstly, one point I will show you matters what the contents raised. Page number 3.
No, let's go serious, Mr. Kumar. First come to 201.
201. Sorry. 201. Bottom last one. In that what the contention recorded. For that I am answering at page number 369 minutes. Say 60 meter stretch only. To that part, I have answered at page number 369.
Where is your extension?
I will come to that one.
Sure.
Yes. Kindly turn to page number 120. Sir. Kindly 22 page number 44 and 45. It starts from there.
You have to only show us the letter.
Yes, I will show that letter, madam. Kindly turn to page number 54 minutes. His request also starts, that's what I just mentioned. Page number 54 minutes. There, it refers to 8th number 2012 letter minutes. 8th number 2012 letter is found at page number 39 minutes. That is 2nd January. Page number 51. Page number 51 months. May I just oppose 51 and page number 54, and may I refer minutes?
See para 1 of your this thing.
That's it. Were pertaining to extension of time and the same has been analyzed and submitted to accepting officer, necessary extension of time due in terms of condition so and so has been granted by the accepting officer, and a DO to this effect duly accepted by you has already been issued. Vide this office letter number so and so dated May 2012. Hence, no further reply needed in this regard. Once it has been granted and given minutes. Now, second.
1 minute, Mr.
Yes,
Kumar.
yes, yes.
These are letters of prior to 12th May, 17th May 2012. This is the first extension.
Yes, madam.
Okay.
Yes.
Where is the reply rejecting the second extension or
Kindly-
granting the second extension?
Now kindly turn to page number 89, months. 89.
Hmm.
89 minutes. In this, the granting has been, kindly see paragraph number 2 minutes.
Where is the rejection or acceptance of extension?
That page also.
Which is the second extension after 17th May.
There is no second extension, it was rejected.
Where is the rejection?
Just 1 second minute, I'll just show it.
Then rejection is you should have terminated the contract.
Appropriately, it should have been done. There was no necessity for them
But
to.
I will not terminate it, I will not extend it, but you will still do the work.
Therefore, I accept the work belatedly done. That.
You can't say so, no? I will not extend, I will not terminate, but you will do the work.
That portion of the work, what has been taken is rightly pointed out, Manoj.
We want to know where is the rejection.
Yes, Manoj, just show it, Manoj. It is there. Because too many places they have placed the very same material. Page number 56 may be seen. Perhaps. '56. Para 2 minutes. Your contention is not agreed to, the work has not been completed till date. In this connection, please refer to this office letter so and so. It is also observed that there is no activity at site number so and so, not taken any action to complete the balance works in spite of it. So is clearly mentioned the stones obtained from the demolish to be used, hence the machinery has to be constructed by using gold stones obtained so and so. Your contention is not agreed to, the thickness of plaster. And his letter reference is previous letter minutes. Previous letter is the reference in which it has been made so much.
Now, why was the deduction 6,42,000?
That's delay of completion. It was 9 months. It was extended up to June.
Then you should have rejected it.
Minutes?
You should have rejected, there is no delay.
That's what you have said so minutes.
Where do you say so?
Minutes, kindly turn to delay parties.
No, you said 56, we have seen 56.
Yes, sir.
You said now, where is the rejection?
Rejection, I'll show it minutes. Immediately it's not coming to my knowledge. I'll just turn that page because only 1 page letter is there. I've seen yesterday. Listen, the statement of objections filed minutes. And number of references also have been given. How many letters we have issued to them for the holding this page number minutes 215 may be seen. 215. volume 2 minutes. Rejection order. 215 minutes. Rejection. 215 minutes. There, as per the work order, the date of completion of the said work was 3rd April 2012. The respondent 1 could not complete his works assigned by the petition in response to the above petition. I issued several notices to respondent number 1 for progress of the work. Letter dated 11/10/2011, 3/12/11, 7th February 2012, 2nd March 12, 14/3/2012, 20th March 2012, 26/3/12, 4/4/2012, 2/4/2012, and 4/6/2012. These are the annexed to. However, the period of completion for the said work was extended for an 1 month, one occasion, as per the request of the respondent number 1 contractor. Request letter dated 26th May 2012, annexure 14. Up
When
to
did
and
he, when did he complete the work?
31st December 2012, minutes, beyond 6 months. This what is the.
Only letter is of relevance is 4/6/2012.
Yes, ma'am.
That is because his date was expiring in June.
Yes.
He made a letter in 4/6. From 4/6 till November 19, you don't decide that a present.
No, it has been decided, ma'am. Only 1 second, ma'am, just get it. It is there, ma'am. We have rejected saying that there are no reasons for you to seek for extension of time. Just only one few seconds, ma'am, just get it, ma'am. It is available. Page, sorry, page number 95 minutes. 95 minutes, so sorry. It's there, marked. $95 minutes. 93, 94 is the letter of the contractor. 95, first one, following parawise replies on furnished to you above referred letter. That is, letter is 26 May 2012. This letter has been addressed on 31st July 2012 minutes. Now kindly see one param. Your contention is not agreed. There was no such rains in the month of May 2012 hampering the progress of work. But it has for 30 days, saying that in the month of May, there was rains. We said there is no rain. It is your responsibility to provide necessary tools and plan for completing work as per contract agreement. Hence, delay on account of non-availability of JCB is not a valid reason for extension of time. Hence, the same is not granted. Then extension has already been granted to you on account of this reason. Hence, the same cannot be considered again. That earlier which we had extended. Next, the reason regarding non-availability labor is not agreed to, as there was no such problem, because it is not within our purview. Then there was no such restriction to hamper the progress of the work due to VIP visit, and hence your contention is not agreed. This reason is not valid in terms of note number 11 on serial number 12 of CA, hence not agreed. Last, he says 60 meter you had given at a stretch, because of that work got delayed minutes. That's why they referred to the note number 11 on serial number 12. That's what I read at page number 369, in which it has been very clearly agreed. Volume number 2. That should get it. Volume 2. I think it is written in page 358 months. Letter dated 27th May 2011. Volume 2. May I read that paragraph, which says that demolition of boundary wall shall not be more than 60 meters length, as in one stretch, and necessary CGI sheet fixed on MS framework, barricades for a height of 3 meters to be provided at site for security purpose, being a operational area during execution of work. The cost of the same is deemed to be included in the corresponding item rate quoted by the tender, and nothing over and above the quoted rate is admissible. That's page number 358, Manas.
Does the delay in completing the contract decided? Who was,
Authority.
huh?
Authority is engineer in charge,
The arbitrator?
not decided. He simply says that there is no delay attributable to the contract.
Where is that?
That's only the, what paragraph I read now, it's the same thing, 193. That is the only discussion with regard to delay minutes.
Which para?
201 and 202 pages.
201?
202. Just last, before claim number 2, claim number 3 starts, in that bottom last paragraph.
How does it start?
It starts with, on this while discussions during the proceedings, it was mentioned by the claimant that CA provisions does not allow for 60 meters stretch only, but it does not debar the GE to hand over more than 160-meter stretches at one point of time. By this way, the work would have been completed in time. Then arbitrator does not refer to any of the records and correspondences. He himself says that I have calculated. There is no basis on how he arrived at, and it is not a part of the award also. The calculation what he has made and basis on which he has made is not part of the award. Nothing has been discussed about this.
Yes.
Minutes. Apart from that, minutes in regard to delay attributed to the contractor, page number 130, that is a statement of defense, clearly stated how many times, page number paragraph 5 onwards, page number 130.
Page?
130 minutes, 130. Paragraph 5. Before quoting his rates, the claimant was aware that total period of the contract is nine months and work is required to be completed within this duration. After taking into consideration all laid down terms and conditions given in the tender, he offered his bid to the department accordingly. All the contract documents, including site documents, site order book, works diary, sample approval, etc., were signed by Sri so-and-so, to whom general power of attorney have been given by the proprietor of the firm. After issue of work order, the claimant was advised vide so-and-so, Elankan letter number so-and-so, to make adequate arrangements for TNP required for execution of work and to forward the sample of all material as per CA within 1 week for approval. The claimant did not pay much attention towards directions issued and adopted a casual approach in arranging the labor, procurement of materials and TNP, etc. The details of quantum of labor employed, skilled, unskilled, materials brought at site and TNP deployed as per works diary is given in paragraph so-and-so. From the details it may be seen that from 4th July 2011 to 24th July 2011, the claimant has employed no labor. From 25th July 2011 to 30th July 2011, the claimant has employed 8 numbers labor. Only steel bars 16 ton was procured on 22 July 2011. Cement 200 bags, 250 bags, sand and 22 cubic meter PCC blocks 400 numbers were procured on 2nd August 2011. The labor deployed till 17th August 2011 was very meager, that is 4 to 30 numbers. The material procurement from the month of August 2011 onwards is only 5 to 10 cubic meters and PCC solid blocks 400 to 800 numbers. No TNP arrangement have been made as only one tractor was deployed. The employment of labor till original date of completion, that is 3rd April 2012, has been from 4 to 30 numbers. The procurement of materials at site after approval of sample was also in piecemeal and was inadequate with the planned progress. The inadequate state of TNP can be verified from the works diary details. From the above, it may be seen that no proper resources were mobilized for the claimant. From the claimant above, sufficient labor, skilled, unskilled, not deployed. Sample of material produced in time. The purchase of materials in piecemeal and not adequate TNP are deployed only when required at site. This proves that financial capacity of firm and arrangements made with GPA as contemplated by the claimant so and so. And next paragraph, 6. Here we are given again the manner in which the total work he executed, total amount. And there also you have said clearly what is the percentage of work was going on due to despite expulsion.
Where is the finding on the arbitrator
Nothing.
on delay?
That is the only dilemma. Nowhere it is in
Your stand.
No. In the entire award, page number 201 is the finding of the arbitrator, not my standards. Just now what I read is my stand, but arbitrator's finding is only in page number 201 and 202. That's the only submission, findings minutes. Nowhere else in the award he has discussed about the delay attributed and delay part. Not discussed about any of the material what we have placed.
Which page? Till November, you don't even reject his request.
It's not.
You don't reject.
It is not rejected. His request for extension of time was rejected.
When?
But July 2012, 31st July 2012, page number 95 minutes. Page number 95, but the work has been accepted till the end, 31st December.
So now tell us one thing, is the time the essence of contract? No.
There are two views. The courts have held that still agreement says that when there is a provision.
All has to be in facts. Agreement says many things. Actually, that means anything, none.
But one view is there, Malars. In entire the government contracts, what I have seen in CPWD, MES and railways, the mechanism what has been made out is that when it's specification of work, amount is specified, and if there is any delay attributed to any party,
Yes.
there is some element of increase in prices based on the agreed terms.
No, we have also seen those contracts where the obligation is on the government to give the site is not given. The poor contractor is with his, materials, everything lying there.
Madam, today's scenario is little changed, madam. It's not so what has been expired certain days. Now, see, just things have been changed because
But tell us one thing, meaningfully read, the position is this. He applied for first extension, he got the first extension till
Sir.
June.
True.
2/4/June, the June month, 2012, he applies for further extension.
Yes.
According to you, you rejected in July. If rejected in July, you should have terminated the contract.
no, there could have been the.
Technically,
True, madam.
legally,
Yes, madam.
once you have rejected the time,
Yes.
the contract qua him came to an end on 30th of June.
Of course, madam, certainly, because once the term is not.
Allowed him to do despite your rejection? How would you reconcile your action? I have rejected, I have not granted extension, I am allowing him to do it.
But one element is there, madam, so there are two aspects. If the work is permitted to be continued without extension of time, also, what I mean, he undertakes, that part, whatever is there is delay. See, only one view is that if I don't grant the extension, does not mean that he cannot complete the work. He may complete the work, but it is a risk of his own, saying that I am a.
But in this case, that claim is you have recovered.
Yes, madam, because delay. Because whether I extend the time or not, even if I had extended the time also, without prejudice to my rights of living compensation.
Which of the letters says, I am rejecting it, you are liable to be, pay, or you are not liable to be paid, or any payment made, liable to be recovered.
That is goes with the condition of the contract itself. There need
must-
not be.
you
Contract
must
itself
show
is
us-
there.
show
I will kindly minutes. The paragraph number 11 may be seen. Sorry, madam. Volume 2. Just. Condition number 65.
Page
Number 438. Sorry, not 6. I'm sorry, madam, only one second. So page number 422 months. 22.
Page number?
422. Printed page number 56. Volume 2. 50. Compensation for delay. If the contractor fails to complete the works and clear the site on or before the date fixed for completion, he shall, without prejudice to any other rights or remedy of government on account of such breach, be liable to pay compensation as under. In the case of term contracts, 1% of the estimated value of the requisition or the works under for every week that the whole of the work remains uncompleted. In the case of other contracts, 1% of the contract value of the item or group of items of work, excluding the contract value of such individual items as are completed and taken over by GE on or before the dates fixed for completion in terms of condition 49 hereof, for which a separate period of completion is given in the contract for every week that the whole of the work in respect of the item or group of items of work concerned remains uncompleted. Even though the contract as a whole be completed by the latest date specified in the contract for any item or group of items work. For the purpose of this condition, the contract value shall be the value at contract rates of the work as actually ordered, including all deviation, orders, escalation amount. When the delay is not a full week or in multiples of a week, but involves a fraction of a week, the compensation payable for that fraction shall be proportional to the number of days involved, provided always that the total amount of compensation to be paid under this condition shall not exceed as mentioned below. In the case of term contracts, 10% of the estimated value of the requisition or works are under whole In the case of other contract, 10% of the contract value of the item or group of items of work for which a separate period of completion is given. Amount of retention money plus compensation during currency of contract shall not exceed 10% of contract value. Contractor shall furnish BGB or fixed deposit receipt in lieu of retention money, and if compensation amount is not fully met from the contingent money.
Where is the stipulation that if an amount has been paid, you will recover because of the delay?
But the delay is compensation for delay is dealt in section condition number 50, which says that if the contractor fails to complete the works and clear the site on or before the dates fixed for completion.
This is a term contract or other contract?
But it's a term contract.
So how much is the total contractual value?
85 lakhs, 80,000. 85 lakhs.
And how much is 1%?
Based on that, it comes around less than. No, it's not going with the exact directly on the amount. Number of days delay is for 6 months. 6% maybe. Around 6% could. 1%. 1%, but for 6 months from June to December.
How much is 1%?
That's
8,000.
no, 85 lakhs. It comes around. Correct.
10% is 85.
No. It's not the case. Is per week manners. 1% of the estimated value of the requisition or the work order for every week.
Yes, let's ask. Yes,
Week
ma'am. What
basis.
do you say on the second case?
My lord, in this particular case, my lord, it was the delay was not only because of we did not have a procured material. It was also because they did not give us site because these are due to security reasons.
No, where is the finding of the arbitrator that there was no delay on your part or delay is explainable? Where is that finding?
Not the only the arbitrators and that particular page is very clearly told, my lord, in condition number 3 clause, the claim 3, my lord, where he is told. He's further also stated about one paragraph of on the delay, my lord, in claim 3, in page number 202. May I read that, my lord? Only he stopped while when he stopped while the arbitrator did some form of calculation and showed that this many days it will take to complete the work. But however, my lord, to go on, more so I have gone through the rival.
But tell us one thing. How can he say that it will take 562 days? That means it is more than 1 year. They have fixed the period as 9 months.
No, but with that calculation, that was just his calculation to show that it will take sufficient.
See, it's like he could not have done that. He said 9 months they have prescribed. No, it would be 18 months the work will complete. That's none of his. Contractual is 9 months. It is for you to take a call. He could not have said this work would take that much. And then say, okay, I will. It's not his job.
But
No.
with that calculation, he's not done anything further. He's just.
You're right.
calculated, my-
You're right. But where is the finding of the arbitrator that there was no delay attributable to you?
No, but subsequently, it goes on to tell, my lord, more so I have gone through the rival contention of both the parties as contained in the written submission and also heard the oral arguments. I also pursued the provisions of condition 11 of IAFW 2249 relating to time, delay and extension, and condition number 50 of IAFW 2249 relating to compensation of delay. I am of the opinion that to make decision of accepting officer as final and binding in respect of extension of time, first and foremost requirement is that the accepting officer has to take a reasoned decision and convey it to the contractor through GE in writing. in the manner prescribed in condition 11A of IAFW 2249. However, request of contractor for extension of time up to and include 31st December 2012 has not been decided by
Now,
the accepting
this
officer.
he is contesting. He said July 2012 it was conveyed.
My lord, that what the reply was pertaining to a different letter, my lord, which I had asked. That letter I have here.
No, see 54 page.
54 pages pertaining to 27th November 2012, where they have told they've
No,
extended.
56, 56.
But 56 is pertaining to my different letter, my lord.
Is it 56?
95 is the
95.
95. So, this is
95.
pertaining to 26 May 2012 letter. That is at page number 93 and 94.
This to a 95 page number was pertaining to my different letter, my lord. Para 1, para 2, para 3.
Now, what is the letter about?
Yes, that letter is there in page number. It's a handwritten letter, which the
94 only, last paragraph minutes. In view of the above facts, I request to grant 90 days.
in page number 47, my letter is there in page number 47, which I wrote in the month of May, my lord. That was what was rejected, my lord, not the, I've asked specifically.
Now, tell us one thing. Once your request for till 30th of August was rejected, will that mean that you can come, your request for till November, December is accepted? It can't be. For an earlier period, it is rejected.
My
You're
lord,
getting, till August, it was rejected.
yes, my lord, but this
Your
was.
prayer is for August, not till 31st of the work. You see your prayer. In view of the facts, you see that page 94,
Same, one and the same.
Yes, my lord.
the handwritten
Yes, my lord.
on that side. See the prayer, in view of the above facts, I request to grant 90 days time for completion of the work up to including 31st August.
1st August 2000.
That was rejected.
Yes,
So
my lord,
once
this-
till 31st August was rejected, how do you expect you will get time till 31st of December?
My lord, here, specifically certain things was accepted. Like for my lord, here what is asked delay was because of rains and because of non-availability.
You are right. These would be the reasons. See, ultimately, he's seeking, because June it has expired, completion. Till August, he says, till August you extend, you reject. Then he again make a request possibly till December. That they did not reply, but this 31st August, once they have rejected it, and even on 31st July, when they rejected it, that's a rejection against you. There is no extension. Now, he is relying upon that if the delay is attributable to you, 1% every week need to be recovered. Okay, now this bill, this 6 lakhs, have you overpaid them
No, you have adjusted against the amounts due.
No, my lord, they have.
for that extended period?
Whatever the bill, what we have work here completed, you have to pay the amount. We have paid the bill amount. Out of that amount, it has been adjusted according to my instruction. Yes, please. Final bill amount against the amount due to him towards the work done. In that amount as well.
That-
But tell us one thing. Let's assume 6 lakhs is not payable, 1 lakh is payable.
To him,
Ah,
a certain limit. Some amount is liable to be paid.
but how can we sever the award? You can't sever the award.
But the entire, my contention is, my lords, including the whatever the small amounts he awarded towards few claims also, are all contrary to the terms of the agreement, because work executed in terms of the specification can be accepted. Why we rejected is, he did not, he asked, requested for the money which is not towards the specified work. He says, instead of 45 mm, I have made 60. I can't pay that, because amount is fixed for that 45 mm execution only. If he says that I have executed, please give me more, it is not a contractual termination. So that's why we have rejected. But still, our learned arbitrator said that neither he said that we have directed him to work to that specified width. He did not say anything. Simply he awarded. In few claims, other way around. He said in writing he should have accepted, then only, otherwise you can't. So in both places, he himself has played put in his own decision in a different footings. On the very same logic, we have taken a contention that according to condition of 50, we are 23, we have to give everything in writing.
How did you quantify your 6 lakhs claim?
That letter calculation will be there in the final bill, Manage. I don't think it is part of this document. I can.
The final bill
A final bill, in the final bill, that amount. Final bill,
is the final bill amount.
final bill. Final bill.
My lord, in this particular, when they are deducting the compensation also.
It is there in the
they are
final bill, final bill.
supposed to give us one notice for telling that they are going to deduct the compensation amount of so much amount. But however, in this particular case, they have not even communicated to us that they have, they are supposed to tell that is the.
Which clause says so?
My lord, that is also looked into by the, it is, in our, the order, my lord, that's also been told in the order also very clearly that they are supposed to give a compensation notice to the parties which they have not given. And in this particular case, they have also backdated, my lord, and one particular aspect is the notice which they sent shows us the date of 4/6/2012. However, the dispatch shows us 8/1/2013. That specifically when we asked, when the question of compensation notice was not issued to us, when it was asked, my lord, they told.
Where is the stipulation? What does the stipulation say? Where is that stipulation, ma'am, in the contract?
Compensation notice.
Of notice.
Compensation of billing.
Appears one notice has been issued to him on 4th April 2012 itself.
Where is that stipulation?
My lord, it is in page number 395, the time, delay and extensions.
Class 11. Page number 394.
394.
395.
Which provision?
And it's
There is no such provision where the extension of time is rejected. Then what will happen? This extension of time granted, then there would be no
Claim for as far
no
as
claim in respect of compensation or otherwise
As-
for idle labor, idle machinery.
nothing
But what if extension rejected?
rejected. Work is accepted after the time.
That's work is accepted and your letter doesn't say so.
So here,
That's subject to recovery.
there is a delay, what?
You show us one letter. Even that 31st July doesn't say so.
It only replies to the letter.
Okay, although you say no extension.
Yes.
You should have said subject to the work done between till the completion. Liable to be recovered, whatever is there.
For delay.
Delay. The arbitrator doesn't say so. But we are putting it to you.
No, settlements. This is a matter which requires.
How would you answer?
I mean, according to my instruction manuals, they have simply accepted the work what has been done after the.
After that.
There is no further communication. If at all, their minutes, bulky records are but not placed before the arbitrator, all records. Yesterday, I have seen the original file and this, there are so many files which are very relevant, papers, not placed.
This was not there.
No, these are all whichever placed before the arbitrator, I have placed your lordship, before lordships. But I have seen the other file which contains many relevant letters which are not part of the records placed before the arbitrator. That was my difficulty to link certain things also. Yesterday, I went through the file.
So, Mr. Kumar,
Yes, minutes.
you reject it.
Yes.
You don't say so, recovery. When did you recover the amount?
And after the completion of the work on it,
Oh,
while
December,
preparing the final bill.
Final bill you recover.
Yes. Because amount was.
6 lakhs odd, 1 lakh odd. That's the total award.
Yes.
Ma'am, tell us on interest. 18% is high.
12%.
No,
How much
the
is, he says
arbitrator,
it in
while
here,
he was,
past interest?
the arbitrator, while he was looking at interest, is also given
Future
the
interest.
specification of why he has gone into the aspect of interest, my lord.
He has granted 12% only.
Yes, 12%. They claimed, but 12% has been claimed.
He gets 12%.
Yes.
12% is fine.
And he is also justified of how he is giving that interest by he's quoted the Honorable Apex Court judgment and then he's looked into of giving the
The power
concept of
to
interest. my lord.
grant interest is not in dispute, madam. The period for which the amount could be and also the amount and both sides, it can be balanced in a way to be little appropriate.
What?
This compensation amount to be allowed. So our that amount award it will be.
On a prima facie view, you may be right. And the finding of fact is wrong that there was no rejection. There was a rejection. But we ask rejection continued. See, it's very anomalous. Once you rejected no extension, how can you work?
It's as good as termination in a way.
Exactly.
I understand that. On that point, I cannot say anything beyond.
So you allow him to work. You don't convey in your letter.
That you will finish.
You can't convey.
Because there is no contract.
That amounts to termination itself. You should have conveyed, look here, this is something we are in 34, Mr. Kumar.
34.
Tell us, ma'am, tell us how much interest. Have you now, is execution file?
No, I have deposited entire amount here only.
Oh, you have deposited?
Deposit here only. 15 lakhs. May I request minutes,
We'll take a submission. We'll take a submission. We'll record that.
Lordship, may I appraise your Lordships on one point. After rejection of his request for extension of time up to 31st October 2000, sorry, August 2012, what other correspondence made and what was there from their side? Can I appraise your Lordships? So that.
Let's not go into for this small amount. Ma'am, tell us on interest.
12%, because we have, my lord, it is
Government
not only that.
government
my lord,
agency.
I have also gone
these
through.
are
huge-
exchequer
I have-
amount.
I have gone through huge loss, my lord, because of because of the delay, and then apart from that also, my lord, because of their own delay also, I have bought the materials and subsequently I had to keep the materials because they did not give me the next part of erection, my lord, because of which also I was subjected to huge loss in this particular contract itself, my lord. And not only delay, my lord, not only the cost, subsequent to that also, I had procured lot of materials, my lord. As he is telling, additionally, I did not have contracts for doing lot of additional work. However, my lord, because I was also an ex-army person.
Where is the finding on interest?
Interest is page number 200 and, sorry, 208 maybe.
200?
Lord, he go.
205, 204 and 205.
Lord, in 205. I have examined. the
Past and
circumstances.
pending lite as well as future interest, all the three have been.
What do you say? Supreme Court says reasonable 12%.
This is a case where on facts it requires to be. I not.
On a principle. He said 12% interest per annum as reasonable rate.
Could be minutes, it varies with facts of each case, but in our case, keeping in view the manner in which that issue has been decided and granting some past and pending lite from the date of award could be also some bank rate of interest could be looked into. That may by the interest.
See, we can't say, okay.
No,
1
that
lakh
I understand,
justified,
madam.
6 lakhs is not justified, interest is justified. We become arbitrators ourselves. That is not permissible.
Not. Apart from that, minutes, either it should be set aside as far as the.
That's not, you have not made such a case.
Because my content is very clear that
Not on
without
fact, such a case where we can prima facie perverse finding. Perverse finding is the actual contrary to public policy. That is not the case here.
Madam, firstly, with regard to delay analysis, it is the one which exactly I am saying this is patently illegal. Reason is this. He himself says that this is the time required for execution of the work. Where is the basis for it? Where it has been said? Our own
He
period.
gives reasons, Mr. Kumar. He said there is rainfall. How will I construct?
No, that is not his work. I am talking about the arbitrator himself. He calculates for 60 meter.
That we have expressed. That he could not have done.
In the apart from that, he should have
fixed.
He should have taken.
It could be 2 years.
He should have taken into consideration the correspondence between us. He himself has requested a time, giving certain reasons. Those points should have been discussed. Then, if you had arrived at some just conclusion, certainly your lordship would have been justified in making this.
7 lakhs.
Uploading.
What do you say for 9% interest? Just reducing 3, then we will be recording your submission. Then we will say it could be 9%.
My submission is to set aside the award itself.
That's not the case. On fact, surely not.
I understand, ma'am.
See, there is we can imagine, you have conveyed, look here, this is what, we are not extending, we are terminating. End of it.
2 months.
Lord, in this particular case, as I told, the huge loss from 2011 itself, he's
Very
taken
well.
advance and all those. So.
Then yes, Mr. Kumar.
This is the
Because still he is paying interest, my lord, because still he has been paying interest for certain things, particularly with this.
And that's none of,
Yes,
we
my lord.
can't
So,
take into that.
But because
Let's
of
be
this, there
very
is-
clear. That's not the
clause.
subject matter here. We are confining ourselves to what is there before us. Okay, and the justification. Very well, Mr. Kumar, there is some justification for the arbitrator. Based on Supreme Court judgment say that 12% is reasonable.
But my lord, given by the factual position on two counts only, I'm just making submissions. The small amount amounted to 1,85,000, what has been awarded, is also contrary to terms of my contract. That's what I might submitted. In one breath, he says that any work you have executed beyond the specification should have been in writing. In few claims, he accepts other wrong. That's one part. Second part is, my lord, as far as the delay analysis is concerned, it is not based on any material. It is his own assessment without there any factual foundation.
We see from a different perspective. Forget the first one, 1 lakh it is, second one, 6 lakhs. You are right that arbitrator says there is no extension. They slept over it or they did not decide. That may not be the position. You decided, you said, of the beyond, we can't extend it. Okay, that's a letter of July.
Certainly.
But what really is, in a way, is surprising is, once you have not given extension, would you not like to terminate it?
Then I may have to lay upon section 55 of the Contract Act to some extent, my lords, where my right will
We are not understanding. You could have said simple. We are extending it, but without any increase, without any escalation. You should have only said that.
There are two things are there, my lords. In class 11, there should be reasons to extend. There are no reasons according to us.
You are not understanding.
Yes.
You say, see, look here, ABC reason, the delay is attributable to you. We have already extended till June.
Certainly.
Though there are no reason for us to extend further.
Certainly.
Because of the reasons attributable. But in the larger public interest, because the project is such, you can't terminate and retender and get the work done.
True, man.
It's just for security reasons you have done it.
Certainly.
We are extending it by this date, but no escalation, no charges, extra charges shall be payable.
No, that should have been, your lordship is right, absolutely right, my lords, on that point. I will not say that, because even if you are granted the time without levy of compensation or with levy of compensation or without any compensation, he could have made a claim. Here, my lords, section 55, what I request is, my lords, the effect of failure to perform at fixed time in contract in which time is essential. Now, my lords.
No, here we will not take it. Here time is not essence. Why did you extend it till June?
My lords,
when time is not the essence, time is the essence, you could not have. So there no time is the essence, stop.
Certainly.
Terminate.
But in all contracts, practically, it is written so and it is extended.
He is himself accepting in all contracts, normally in.
Extension is there.
Especially in
Many a times.
civil
You
contracts.
do it now. So in none of the contract, time is the essence.
It is not being held by the very.
It
in
really
various
actual
judgments.
in fact situation.
But still, in the interest of getting the work completed, my lords, that sentence is there. Try to make it.
So what you should have said, we are extending, no extra.
No, that is always there in class 11. Automatically, it should have been said so.
If you had said him, look here, I am be terminated, or you have said it, extending with no extra, he would not have come. Now, what happened in this case? You not extended, you allow him to work. Not telling him that you will make the recovery for this period. He would have not worked it also. You would say, okay, I'm going.
There are two ways of looking at two user possible matters, because contract says that if you work, complete the work belatedly, you are liable.
Okay, I think Mr. Kumar, we have spent a lot of time on this. Come. The challenge in this appeal is to an order dated 9th November 2021, passed by the Court of LXX5, Additional City Civil and Sessions Judge at Bengaluru. In Com AS number 77 of 2019. Which is a suit filed by the appellant herein. Challenging the award dated 29/1/2019 of the sole arbitrator. Allowing certain claims of the respondent number 1 herein. Full stop. Suffice to state, the learned arbitrator has primarily allowed two claims, claim number 1 and 3, and granted interest to the respondent in the following manner. Ma'am, just say claim number 1, 185-970.04. Claim number 3, 642,379. The aforesaid amount was granted with the interest of 319,447 for the period 1st July 13 to 15 September 2016 and interest of 12% 3 months after the publication of the award. Stop. It is maybe necessary to state here that the counterclaims of the union of the appellant herein for an amount of rupees, how much is the counterclaim?
Total amount is minutes.
Claim of union is 1,25,027.
125, no, not 125.
Total amount is 6 lakh.
7 lakhs,
47.
no.
No, Manager, it's not added up. 6 lakh 42 plus 5,000, 72,000 plus 1 lakh 25,000. And interest. It's not been quantified.
for an amount of rupees have been rejected. The claim number 3, claim number 1 of the respondent 1 was primarily for rupees 13,66,592 and was under the heading outstanding under different subheadings with a common claim of outstanding amount of work done as per Annexure 1. The learned arbitrator has awarded a sum of rupees 185
970.
Is that
Page number 52 in the award. In the appeal memorandum.
970.94. The 04, 940. the breakup of the subclaims under claim number 1 is in the following manner, pages 199 and 200, tick to tick. It's in a tabular form. Where is the finding, Mr. Kumar, on this?
For claim number 1, my lords.
Huh,
Subclaims, it started from page number 180.
I know, it begins from very early,
185 is the commencement of the award, my lords. Page number-
192.
Yeah. 192 minutes, correct. Award starts from there.
Where is that finding of you were drawing our attention?
Page number 201 are with regard to contrary statements made by the arbitrator are findings.
The submission of Mr. Kumar is while granting the claims under different sub-claims under claim number 1. The learned arbitrator has given a contradictory finding.
Page number 193, paragraph, top paragraph.
In as much as at the top. Is it at the top?
Top one, stop, page number 193.
In as
top.
much as the learned arbitrator for certain subclaims has denied the same,
Accepting the contentions of the appellant.
has allowed the subclaims by stating that the respondent should not have executed the work without an order in writing. Whereas certain claims have been rejected, certain subclaims have been rejected on the ground that even if there is no even
There is no order in writing. Order in writing.
Even if there is no order in writing, still the respondent was required to execute the contract.
No, my contention is that anything to be done beyond the contract agreement terms, there should be an order in order. So he accepted according to condition number 23.
Just cut the last line.
This may be taken as it is.
According to Mr. Kumar, such a conclusion of the learned arbitrator is contrary to the terms of contract in as much as any work beyond the contract necessarily has to be in writing.
In terms of condition number 23.
As per clause 23 of the
IAFW 22949.
IAFW
2249.
2249.
In few claims, subclaims, the arbitrator accepted that.
And
contention.
such a stand of the appellant has been accepted by the learned arbitrator. We are unable to agree with the said submission of Mr. Kumar for the reason that the respondent having executed the subclaims, the arbitrator has granted an amount of 185,970,04. Hence, 04 by observing that if there was if the work was not allotted in writing, he should not have executed the same. It means despite anything in writing, the contractor having executed the work, he is required to be paid. Next, insofar as claim number 3 is concerned, the same is for payment of reimbursement of the amount recovered towards alleged compensation for delay in completion of the work. So the amount claimed is 642,379. Full stop. The submission of Mr. Kumar is that the work was delayed due to the reasons attributable to the respondent number one. Respondent number one. And respondent number one.
Findings recorded by the arbitrator is.
And respondent number one. But respondent number one, and in that regard, and the respondent number one had made request for extending the term of the contract. Full stop. In all, he made just say that the first request was accepted by extending the period to complete the work till June 2012. The failure on the part of the respondent to complete the work before June 2012, the respondents were within their rights to terminate the contract. But before the period, before 30th of June 2012, a further request was made by the respondent for extending the work till 31st August 2012 and later till 31st of December 2012. Vide communication dated 31st of July 2012. The appellant had communicated to the respondent that no further extension can be granted. Despite such a finding, the learned arbitrator holds that the request of the contractor for extension of time up to and including 31st December 2012 has not been decided by the accepting officer, which is a perverse conclusion. Stop. He submits that once the extension till 31st of August 2012 has been rejected, there was no question of extending the work, completion of work till 31st of December 2012. In any case, it is a submission. It is based on the said finding that the learned arbitrator has awarded an amount of 642,379 to the respondent. Full stop. Though on the other hand, learned counsel for the respondent would submit that the conclusion arrived at by the learned arbitrator is a correct conclusion, in as much as the request of the petitioner of the respondent number one was not decided, and for extension, just say for extension till 31st December 2012, 12 was not decided, and hence he had rightly granted the amount under this claim. We are not in agreement with this plea of the learned counsel for the respondent number 1, as is clear from the letter dated 31st July 2012, wherein the appellant has clearly stated that extension has already been granted, clearly stated that as extension has already been granted to the respondent number 1, the same cannot be considered again. Full stop. But what really matters is if the extension has not been granted by the appellant, whether the respondent number 1 could have continued with the work. The answer has to be in the negative. But we find neither the letter dated 31st July, the letter dated 31st July 2012 specifies as the extension has not been granted, the contract stand terminated. Full stop. Rather, the appellant allowed the respondent number 1 to continue to do the work and complete the same before 31st of December 2012. In that sense, the respondent number 1 having executed the work and completed the same before 31st of December 2012, comma, the action of the appellant to make a recovery of amount of rupees 642,379 on the premise that in view of the delay in execution of the work, the appellant is within its right to recover the said amount.
That's, I just intelligence on page 169. Auto Lordship meets your Lordship's query, what has raised according to me. Page number 163 minutes, page volume 1.
Yeah.
What has been said, minutes with me. The Lordship got it, minutes. May read. The time being of the essence of the contract quoted above, and you have having failed to perform your obligations by the time agreed upon, notice is hereby given to you that in deciding to accept the performance after the said time, government shall claim from you compensation for delay in completion of the work in terms of condition 50 of general condition of contract on account of your non-performance of your contractual obligations by the time agreed upon. This is dated 4th June 2012 minutes. It may be, this is where it has been said, we will accept the work beyond the time, but this is the one which has been given.
My lord, this letter only they dispatched in the year 2013 January, my lord. We had filed an RTI.
How do you say so?
My lord, we had filed an RTI application, my lord.
Show us.
Subsequently in that.
Just show us.
It's marked as exhibit C26, my lord.
We don't have what is the date of the letter? Show us. Was it part of the arbitrary record?
Yes, madam, exhibit P7. P7, page number 1, see, that's
not your letter, their letter, the RTI.
That RTI response. It's in page number 3 from that. The first column. First, the reference number is there, my lord, in that. The reference number is 896791.
8967.
Yes, sir. 91.
Legana Enterprises.
Which page is that? 8967. What is the dispatch date?
It was,
Huh?
My lord, it was dispatched in January 2013.
Okay, okay.
Yes, ma'am.
No, this is 15 December.
8/1/2013, it was dispatched, my lord.
Huh?
8/1/2013.
How do we get that?
My lord, RTI is only taken from December.
Where is the RTI reply? Just show us, ma'am. Just ask them to flag it.
Yes, ma'am.
So this is their answer on this.
Minutes, this is, I don't know, this is not part of the our record. I have to verify minutes.
Yeah, put this.
Yeah, you have an officer, na? Ask him.
He's other transfer last week minutes, I have to find out. If not, there is.
Just show it to him also.
Just show me.
We have asked only from 15th December 2012, my lord. Subsequent dispatches.
No, is there any reply by them that this letter 8967 has been dispatched in January 2013?
No, my lord. Only the RTI shows that, my lord, it was dispatched only in the year 2000.
Where is that? Just please mark that.
They have taken the dispatch register extract.
Obviously, they have asked for an RTI, you gave it.
They are inferring that this letter has been done. I don't know on what basis they are saying. I'm not to confirm.
No, he says 86 there. Now tell us one thing. No, you have to tell us. What was the information sought?
Yes, madam.
And what was the answer given? Just give that.
Give me the RTI letter. Not letter, it's not.
It's 2012.
But this letter of yours
Yes.
is exactly on the point. This is what you should have done. And this is what we were saying.
That's true.
But the answer is, this is countered by this.
Yes. I just have checked.
So you realized later there is some amiss.
No, man, I did not see that.
Obviously.
The officer
See,
who came.
Mr. Kumar, all this contract need to be said, look here, I am doing this is the consequence. Now, when you say time is the essence, I am not doing.
And that deciding to accept the performance
And
after
very
the set time.
interestingly, what you say is now you realize that he has done his work. That in deciding to accept the performance after the set time,
government shall claim from you compensation.
what you have justified, you have worked, but we will take compensation.
No, before completion itself.
Oh.
It is December, it is 4th June.
Ma'am, where is the
2012.
RTI? Show us.
The RTI letter is not marked, my lord, but the
Where is the
dispatch.
dispatch? Show us the dispatch.
This, the dates from when it is dispatched is here on top, my lord. This I have marked here. Here,
Ma'am, just mark it with a pencil.
pen bed answer.
I will have checked matters because I don't think this kind of letter number we can refer to it.
Mail first
Because
one.
the numbers will be of different.
You don't know.
That's what I don't know because it's a surprise now just now it has been.
No,
brought.
this has already been raised. This was also raised before the
Arbitrator.
before the honorable court, my lord.
No, we just show us, is this letter was before the arbitrator?
Yes, my lord.
This RTI.
Seat, it
Was
has been
there?
marked. Yes, my lord. It has been marked.
Show us, ma'am.
C-26. You also to be there. Quotation also. No?
This is what?
My lordship, in list of exhibits, C-26.
Lord, in 36, they have also mentioned list of exhibit. This has been marked as exhibit C-26.
On this submission of Mr. Kumar, the Lana counsel for the respondent number would submit that though the communication referred to by Mr. Kumar, no, let's just cut that, man. At this stage, Mr. Kumar has drawn our attention to page 163 of the compilation filed by him, letter dated, to contend that on 4th June 2012, a communication was sent to the respondent number 1 stating the following. Page 163, just reproduce. According to him, in the said communication, it was made clear that the appellants shall claim compensation for delay in completion of the work in terms of condition 50 of the PCC. Full stop. And hence the arbitrator could not have granted the amount, could not have allowed the claim of the respondent number 1 for an amount of 642,379. So this submission of Mr. Kumar is contested by the learned counsel for the respondent by stating that though the communication, the date of the communication reads as 4th June 2012, but in fact was dispatched only on 15/12/2012, as is clear from the information received by the respondent number 1 under the RTI Act, which was exhibited as Exhibit C-26 before the arbitrator.
Yes, my lord,
Before the arbitrator.
in page 72, which they have produced paper book also, it is there, my lord. Now, which they produced also, it is there.
70?
Two in the page number, in which the paper book which they produced.
No,
my lord.
Acha, in
volume,
the
volume one, volume.
Volume 1.
And the
page
same
7.
is also clear from the, and the same has also been filed by Mr. Kumar in the compilation of documents today. If that be so, the reliance placed by Mr. Kumar on communication dated 4th June 2012 shall not help the case of the appellant. Now, this we say so, that a similar communication was not sent to the respondent number 1 while rejecting the request of the respondent number 1 wide communication dated 31st of July 2012. Full stop. 31st July 2012. And in that sense, in the absence of representation by the appellant about the to the respondent number 1 about the consequence of of delaying the work, then we are of the view that though the appellant had allowed the respondent number 1 to continue the work, but the consequence thereof having not been communicated, the claim as allowed by the arbitrator in the facts, for the reasons stated by us, which are different from the reasons stated by the learned arbitrator, cannot be interfered with. So one of the submission of Mr. Kumar is that the learned arbitrator has granted 12% interest on the amount granted by him in favor of the respondent number 1, which is on the higher side. We find that the learned arbitrator has justified the grant of interest at 12% by referring to the judgment of the Supreme Court in the case of so and so. Stop. If that being the basis, the scope of jurisdiction under section 34 of the Arbitration and Conciliation Act being very limited, that is for the reasons stipulated in the said section, and it is also not the case of the appellants that the award is contrary to the public policy public policy, we are of the, and also in view of the following judgments, we are of the view that the impugned order does not require any interference. Does not require any interference for the reasons stated by the learned trial court and also for the reasons stated by us. Okay.
Two things, perhaps, including the stated section 34 in the order, does not address any of the grounds urged by us.
That's
So
the reason, Mr. Kumar, we are conscious. That's the reason we are saying these reasons. We are conscious of that. You are
Okay.
right.
Second approach, perhaps,
Yes.
some relief in terms of interest may have to be considered. What from that matters past and also independently.
We are not saying anything, Mr. Kumar. We are in 34 jurisdictions.
But may be permitted to withdraw they've deposited the amount, my lord, may be permitted to withdraw the amount.
How much is the amount?
15 lakhs. 14,57,000 has been deposited. 14,57,279 rupees. Up to 30th May 2022.
Where is the?
It is there in the.
May just show us that.
Yes, in the order sheet is even recorded.
This is 2020 they have paid.
Pardon?
They have paid this till 2020, my lord. This was deposited before the honorable court in 20.
No, 22 months. It's on 3/9/20.
22.
Up to that it has been.
Mr. Kumar, we can do this. We can still give you may have a remedy for appeal. We can still say, so this amount is deposited. In view of our order, it will be released to them, but only after a particular period.
Otherwise,
That will give you a period to see whatever remedy you have. That's what
So
we will be
protecting the interest, it can be released.
Pardon?
They can give a bank guarantee and they can issue a bank guarantee. The entire amount can be released.
No. That's open-ended. You would not go there. She will continue to give bank guarantee.
Some time frame fixed.
No. Just at this stage, learner counsel for the respondent. Respondent number makes a request that the amount as deposited by the appellant before this court. When did you deposit, Mr. Kumar?
So when did you deposit?
No. What is it? Do we have the?
It says 3/9/22 months. It's order sheet shows, sir. Deposit
Pursuant to the order dated 21/7/2022 on 3/9/22.
No, amount is
14,79136. Be released in favor of the respondent number 1. We'll stop. Then noting the said submission in view of the order passed by us in the appeal, we deem it appropriate to direct the registry to release the said amount with interest, if any, to the respondent number 1. But only after 8 weeks.
at least
You
12
want 1
weeks.
year,
12 weeks.
8 weeks.
12 weeks minutes, because at least if at all any steps are to be taken, it may take consideration. 12 weeks may be taken.
We have given you 8 weeks.
12 weeks may be, because it takes little time to proceed. So, but if at all they want to take any further steps, maybe candidate.
8 weeks from today. To the, what is the status? This is a proprietorship concern.
Yes, my lord, it's a proprietorship.
To the representative of the respondent number 1, duly identified by the council and also in the presence of the council.
It is without prejudice to my rights to take.
What is this? We say nothing. That's the reason we have given you 8 weeks. Go if you want.
I request little more time, my lords, because it takes little time to get the things processed, maybe 3 weeks or more.
This is an order which is not, otherwise you are not required even a day, once we have dismissed it. Thank you. We'll just get up. Yes,
Sure.
Number 2, my lord, serial number 5. Let's,
we are not touching that list. It will remain as it is.
why? Because my lords, there is some difficulty this.
Whenever the matter is, just make a request on that day.
Please.
We say nothing on that. Thank you.
Dispense ಮಾಡ್ಬೋದಾ?
ಏನದು? ಸರ್ ಸುಮಾರು ಕರೀತಾರೆ.